Good morning, everyone. We are here today for the Special Board of Correction hearing on PREA. Jennifer Jones Austin, anyone hear me? No. Jennifer Jones Austin, one of the board members, will be coming today, but coming late because of a family medical issue. Is that any better? Yeah, thanks. Before we get started, I'd like to thank the Administration for Children's Services for allowing us to hold today's hearing in this great auditorium here at the ACS Children's Center. I'd also like to thank the board's monitoring and research staff for doing a wonderful job preparing the board for this hearing and conducting and issuing many new and important studies and reports. The focus of today's meeting is on the implementation of and the compliance with the board's minimum standards regarding elimination of sexual abuse and sexual harassment in correctional facilities. The board's standards are designed to detect, prevent, and respond to sexual abuse and sexual harassment of people incarcerated in jails and other facilities in New York City that are operated by the Board of Correction. Today, we will hear from the Department of Correction and New York City Health and Hospitals Correctional Health on their efforts to ensure compliance with the minimum standards. We also are joined by the Bronx District Attorney, Darcel Clark, and members of her team, and also Vanessa Puzio and Joan Valero from the Manhattan District Attorney's Office, both of which offices play a critical role in pursuing criminal charges related to allegations of sexual abuse in the city's jails. Council member Helen Rosenthal and the Department of Investigation have also provided written testimony to the board, which will be on our website. We also welcome the Westchester County Department of Correction and thank each of you for being here for this critical discussion. Finally, we welcome and thank the public for your critical engagement on this issue, and we look forward to your comments as well. One additional housekeeping note before we start: we understand and appreciate that the schedules of many people here do not allow them to stay for the entire length of the hearing. As always, we are live streaming the hearing now. There will be a recording of the hearing posted immediately following our conclusion, and we will post draft hearing minutes in the coming weeks. Additionally, DOC and CHS staff will be present here throughout the hearing. As background, we note that in 2015, the then New York City public advocate, Letitia James, petitioned the board to adopt rules consistent with national PREA standards enacted by the Department of Justice in response to the epidemic of sexual violence in the nation's prisons and jails. After several months of fact-finding, a public hearing, and written comments from over 60 organizations and 60 individuals, this board, the Board of Correction, adopted a new minimum standards in 2016. The rules incorporated into local law the federal PREA standards in whole or in part, thus securing local oversight and enforcement of PREA. The board's minimum standards also include New York City-specific requirements such as race crisis counseling and extensive public reporting. It has now been just over 2 years since the minimum standards went into effect, and today's hearing is an important opportunity for us to review the work that has been done while identifying areas of continued concern and plans to address those areas of concern. Today's hearing is part of the board's continuing commitment to ongoing oversight with respect to the minimum standards. As will be discussed at length over the next few hours, the board has seen the department make some significant progress in implementing the minimum standards. Progress includes increased staffing, significant training, and new procedures for the Investigations Division's PREA team, leading to increased case closure. Over the last 2 years, the board has also documented and worked with the department to address serious compliance issues. Additionally, we continue to receive significant and problematic reports on the continued threat of sexual violence in the city's jails. While progress has certainly been made, much additional work remains to be done before we reach an acceptable level of compliance with PREA. I will now ask our Executive Director, Martha King, to review the history and where we are today.
Thanks, Derek. I will briefly just go through some history and then focus more on the reports that we released yesterday in conjunction with this hearing. So since the standards were implemented, every 6 months, the board staff have published compliance dashboards and reported at public meetings on the progress and challenges in DOC's and CHS's implementation of the board's Chapter 5 standards. The board has focused its attention on screening for risk of victimization, the use of that screening, the safe housing of transgender people in custody, and investigations. In June 2018, the board found the department non-compliant in completing PREA investigations within 90 days as required. At the time, there was a backlog of 1,295 cases. In response, the board and the department discussed corrective action, and DOC submitted a timeline for completing its backlog of investigations and improving its management of cases moving forward. In October 2018, the board published an audit assessing DOC's investigations of sexual abuse and harassment allegations made by people in custody. The audit uncovered significant deficiencies, including missing supervisory approval of investigations, key interviews that were not completed, and insufficient explanations as to why crime scenes were not established. The audit found that investigations took 510 days to complete on average. In response, the board unanimously passed a resolution identifying actions for DOC to cure these violations, including the adoption of the board's audit recommendations and submission of a corrective action plan by November 2018. However, in November, the department had not submitted a plan, raising concerns and contributing to the board's decision to schedule this special hearing today. After further discussion, the department submitted a corrective action plan for improving its PREA investigations. As of March 2019, DOC reports it has closed over 1,000 cases in its backlog, improved its investigations closing report form, and increased the number of investigators and supervisory staff assigned to these cases. In preparation for this hearing, board staff created and shared several new public reports. As is our quarterly practice, we released updated dashboards documenting the required reports and submissions from DOC and CHS. We also released a series of data tables summarizing the data reported to the board by DOC. DOC's PREA investigations team received a total of 1,141 allegations in 2017 and 1,326 in 2018, representing a 16% increase in the ID teams and the PREA ID team's caseload. The number of PREA reportable allegations decreased 19%, from 643 allegations in 2017 to 524 allegations in 2018. This corresponds to an 11% decrease in the rate of allegations. The number of non-PREA reportable allegations increased 61%. In 2017 and 2018 combined, 65% of PREA allegations were designated as staff on persons in custody complaints, while 35% involved person in custody on person in custody complaints. 32% of PREA investigations started in 2017, and 78% of PREA investigations started in 2018 still were pending investigations as of March 12th. When we received the data from DOC. Among all closed PREA cases initiated in 2017 or 2018, only 8 cases were substantiated. For all cases closed by the PREA investigations team, we see a significant improvement in time to closure from a mean of 464 days to 146 days, and from a median of 512 to 77 days in 2018. In another sign of encouraging progress, 27% of cases closed 2018 PREA reportable cases were closed in 90 days as required, compared to only 2% of closed 2017 PREA reportable cases. I just want to speak a little bit about the 540 report, which is of great importance to the board. As the board noted in October 2018 in its resolution, the department is not yet in full compliance with minimum standard 540, which requires the department to collect accurate, uniform data for each alleged incident of sexual abuse at its facilities using a standardized instrument and standardized definitions. Most of the challenges associated with providing the required elements are due to the fact that the department does not have an adequate case management system in place, and instead is doing much of the 540 data tracking manually on various spreadsheets, making the data difficult to update throughout the course of investigations. The department reports that it hopes to update its electronic case management system to track PREA investigations by the summer of 2020. In the meantime, the department has committed to the board that it will report all required 540 data elements for all allegations made in 2019 and all cases closed in 2019 by its next 540 reporting deadline in August. And the board and department staff are committed to working together to improve the quality of future 540 data submissions. We also released a report regarding Standard 514, which requires educating people in custody about the department's zero tolerance policy and informing people of their right to be free from sexual abuse and harassment and how to report. The findings summarize a week-long period of observations in March 2019. Between March 1st and March 8th, BOC staff toured a total of 194 jail areas across 11 facilities and 1 hospital ward, monitoring compliance with 514. Staff observed that new admission materials were available at every intake in each of the 7 new admissions facilities. All new admissions materials included information on DOC's zero tolerance policy. In the vast majority of areas we visited, or 82%, all of those areas had PREA posters up with information describing ways to report sexual abuse or harassment and how to make confidential allegations. All posters were available in English, and 95% of the areas with PREA posters also had the information available in Spanish. We also checked compliance with minimum standard 504K, which requires the department implement a policy of having supervisors conduct and document unannounced rounds to identify and deter sexual abuse and harassment. The standards require that rounds be conducted during night shifts as well as day shifts and at unpredictable and varied times. To monitor compliance with this standard, board staff audited 12 housing areas across 6 facilities. We also reviewed video footage for a sample of corresponding times. BOC staff found that the logbooks do indicate that unannounced PREA rounds are being conducted by DOC supervisory staff, and they are taking place during night and day shifts as required by the standards. 71% of the 226 unannounced PREA rounds that we found in logbooks occurred at unpredictable times as required. However, upon review of a sample of those cases, we found it was 37 times that we checked on video, so 38% of those cases we reviewed the video and found that the tours were not occurring as required. So in these cases, board staff observed officers signing or captains, deputy wardens, the supervisors signing the logbook and then leaving the unit without rounding or completing appropriate checks. We've made recommendations in that report about that issue. The last report we issued was a supplementary audit of DOC's PREA investigations. This continues and is a supplement from our September 2018 audit. We reviewed a sample of 20 investigation closing reports, and these were selected because they were closed in the first 2 weeks of February 2019 and thus represented the most recently closed cases that we had received. The supplement finds some areas of continuing concern and others of progress. First, there continues to be considerable delays in the department's investigation. The mean time to case closure for the 20 cases reviewed was 350 calendar days. Only 2 cases were closed within the 90-day period as required by the standards. Second, the board remains concerned that interviews are not always carried out with alleged victims and alleged perpetrators. Alleged perpetrators were interviewed in 9 of 17 cases where it was reasonable to expect an interview to have taken place. Witnesses were interviewed in 70% of cases. These interviews are crucial to understanding the details of the allegation and in allowing the investigator to test and weigh the available evidence. In some of the cases reviewed, there appears to have been too much reliance on Genetech video or existing statements rather than conducting interviews. DOC has improved their recording of where interviews occurred, but when interviews are conducted, they are not always in private and confidential locations as required. There have been considerable improvements in the inclusion of historical information about alleged victims and alleged perpetrators, such as prior allegations of abuse or harassment. There has also been considerable improvement in the inclusion of an analysis of the testimonial and physical evidence in the closing reports. We found that 80% of the cases included review of physical evidence like video, bedding, or clothing, and in 85% of the cases, the investigators demonstrated they had reviewed testimonial evidence. The board remains concerned about the inclusion of any credibility assessments and the reasoning for what is found to be substantiated or unsubstantiated and the quality of those assessments. In 55% of cases, the report included a clear indication of how the investigator decided on the credibility of the various people involved. In a third of cases, the investigator adequately explained how they reached their conclusions on what was or was not substantiated. It is crucial that closing reports include this information. Without it, it is impossible to understand the determinations made by investigators. There continue to be a number of documentation problems in the closing reports. While there has been some improvement in how investigators record the location of victim interviews, the recording of the location of witnesses and alleged perpetrator interviews persists as a problem. The board also remains concerned that decisions regarding the establishment of crime scenes are not recorded adequately. The closing report showed that crime scenes were not established in any of the 20 cases, and while that might be entirely reasonable, the investigator in only 44% of the sexual abuse cases sufficiently explained that decision. The last point I'll make about documentation problems were that there are different closing report formats used by investigators, leading to discrepancies and inconsistencies in what information is collected and recorded. We observed 5 different formats in this sample of 20 cases. So these findings suggest additional work is necessary to implement the existing DOC reform commitments and ultimately to evaluate whether the reforms have led to each and every investigation meeting the minimum standards for timely, robust, and comprehensive investigations, and thus meaningful outcomes for complainants. Each report provides a crucial window into the robustness of the investigation and should be viewed as the primary way to formally document and integrate the evidence, steps, and decisions in each investigation, thereby also demonstrating that the minimum standards have been met. It is the only memo in the investigation file able to integrate the various parts of the file. In addition, the closing reports can and should provide the department with an important tool for their own quality assurance mechanisms. The board advises some caution in generalizing from these findings because of the recentness of the department's reforms and, of course, our limited sample here. However, the 20 closing reports reviewed do provide some insight into the quality and timeliness of the department's recent investigations, and the findings of this report can assist in their continued efforts towards improvement. We've appreciated the department's collaborative, thoughtful, and very proactive engagement with the board through this process, and thank them again for their ongoing work that they have put into this and to reforming the PREA investigation process overall. Our annual audit will be published in the fall of 2019. That's it for me.
Thank you, Martha. Very useful background. So now we'll hear from the department as the first speaker. Thank you, Commissioner.
Doesn't sound like it.
Good morning. I'm Cynthia Brand, Commissioner of the New York City Department of Correction, and I'd like to start by saying that we believe DOC and BOC share the same overall goals: to run a system that is safe, humane, and produces positive outcomes. And we are working every day on how to do that well. I'm pleased to provide opening remarks today regarding the strides we've made at the department in our efforts to become PREA compliant in our ongoing commitment to sexual safety and our efforts to adhere to best practices in investigative procedures and documentation as they relate to sexual abuse complaints. The safety and security of those in the department's custody and of those who work in the department facilities are DOC's primary concern, and I take sexual safety personally and seriously. And before I go further into today's testimony, I'd like to clear up any confusion about the applicability of PREA in correctional facilities. The federal standards and the BOC rule apply to staff on inmate and inmate on inmate sexual abuse and sexual harassment. Any incidents involving inmate on staff or staff on staff sexual abuse or sexual harassment are taken equally seriously. However, they are not classified as PREA matters. Let me be clear. To the extent that there is any indication of potential criminality identified at any time during an investigation in these matters, they are immediately referred to the district attorney's office. Any suggestion that we present a barrier to staff reporting or having direct access to an external law enforcement agency is categorically false. We have zero tolerance for any sexual abuse or sexual harassment against any person. In late 2014, the department voluntarily began the process of becoming PREA certified and began working with the Moss Group, a highly respected national leader in PREA compliance consulting, in order to improve sexual safety across DOC facilities. The partnership between the Moss Group and DOC has rested on an alignment of leadership values and comprehensive and well-planned implementation of strengthened policy and practice, leadership and supervisory development, and transformative and skill-based training. To begin, the Moss Group conducted sexual safety assessment at 7 of our facilities, with a focus on key standards to support system-wide enhancement of compliance with PREA standards. Within 60 days of receiving the Moss Group's sexual safety assessment in the department, we began a system-wide effort to institutionalize policies and practices that support and sustain PREA compliance and the prevention of inmate sexual abuse and harassment. Over the past 4 years, the department has moved to create and fully staff a PREA investigation and compliance team within the investigations division, implement a comprehensive PREA policy that focuses on inmate safety, deliver initial and refresher PREA training courses to all uniform and non-uniform DOC staff, as well as all volunteers and contractors, and provide all individuals in our custody with internal and external confidential methods of reporting sexual abuse allegations. The department remains committed to preventing sexual abuse through proper risk assessment and the provision of safe housing. Every individual who comes into our custody goes through an intake process that includes a safety risk assessment. This assessment considers a number of factors that may make an individual vulnerable, including previous sexual abuse, nature of the crime of which they are accused, sexual orientation, whether the individual is small in stature or appears gender nonconforming, and it advises on the need for special housing. In accordance with Executive Order 16, the department is committed to housing individuals by gender identity and created a first of its kind, in fact, first in the nation, transgender housing model. If at any point in the intake process an individual identifies themselves as transgender female, the individual is transported to the Rose M. Singer Center to complete the intake process and be housed in a transgender new admission housing. Following intake, transgender individuals have the opportunity to be housed either in the transgender housing unit, commonly known as the THU, or in a general population housing facility with cis female individuals. Regardless of where they are housed within RMSC, transgender inmates have the same access to programs, education, and health care as all the other women in Rosie's. Transgender female individuals can also elect to be housed in male facilities so long as it does not present a security risk. To date, all transgender men in the department's custody have been housed at Rose M. Singer, and should a transgender male request to be housed at a male facility, the department would make the necessary accommodations after evaluating any potential risk. Over the past year, the department has worked to further enhance its PREA processes by implementing all 8 of the board's recent audit recommendations, as well as implemented and executed a corrective action plan to address an outstanding administrative case backlog. I want to emphasize that all PREA cases, all allegations, are investigated within 72 hours. But due to staffing shortages, finalizing paperwork to administratively close cases had fallen behind. As a result, the department implemented an aggressive corrective action plan that required the closure of 1,216 sexual assault cases, raising the staff of PREA investigators to 30, and hiring of additional PREA team managers by the end of February 2019. The department successfully met this goal, and I am incredibly proud of the hard work of everyone who contributed to that effort, especially the PREA team. The department has worked collaboratively with the Department of Investigation, the city's district attorneys, to appropriately handle sexual abuse and sexual harassment complaints. Every sexual abuse case that comes to the PREA investigation team is immediately referred to DOI via email. The PREA team awaits notification from DOI that DOC is authorized to proceed before commencing its investigation. This process does not measurably delay our investigation because DOI is prompt in giving us their reply. If during the department's investigation, investigators uncover evidence that supports criminality, the department then refers the matter back again to DOI and/or to the DA's office. In the coming months, the department will undergo a federal audit to assess its PREA compliance. The preliminary results of a mock audit at the Rose M. Singer Center performed by the Moss Group have yielded promising results, which I am happy to share a copy of with the board later today. The mock audit indicated ratings of compliance with 74% of the standards and 92% of the substandards. In comparison, a mock audit in 2016 indicated ratings of compliance with 17% of the standards and 31% of the substandards. The auditor was impressed by how knowledgeable the correction officers and other staff members were about PREA, their first responding duties, and evidence collection. Also impressive was the testing for recruits, measuring the level of understanding staff had retained following PREA training. I am further encouraged by the Nunez Monitor's report, which showed that the department has continued to improve in its PREA compliance and in the timeliness of its case closure rate. In order to evaluate the quality of the department's investigations, the monitoring team evaluated investigation files for half of the investigations closed during the recent monitoring period. Although the report noted areas wherein the department could improve, overall, the monitors found, and I quote, improvements over cases reviewed in the past, particularly in timely response to the scene, interviews with youth witnesses where investigators are asking key questions and relevant follow-up questions, and detailed synopsis of what was viewed on Genetec or handheld footage. The monitoring team report concluded that the PREA investigators' findings were reasonable based on evidence, and that overall, significant improvement in the timeliness and quality of investigations of sexual abuse is evident, and the monitoring team is encouraged by the department's progress. I credit this improvement to the hard work of Assistant Commissioner Faye Yalardi, Senior Correctional Administrator Prichelle Shannon, Deputy Commissioner Serena Townsend, and the entire PREA team, the hard work of the department's leadership team, and our officers' dedicated commitment to sexual safety. At this time, I will invite Deputy Commissioner Serena Townsend to the podium to provide testimony on behalf of the department regarding PREA. Thank you.
Thanks.
Thank you, Commissioner. Good morning.
Morning.
My name is Serena Townsend. I'm the Deputy Commissioner of Investigation and Trials for the Department of Correction. I am pleased to speak with you today to provide information and updates to the department's efforts to become PREA certified, the strides we have taken to address concerns previously raised by the board and the City Council, and our collective efforts to increase sexual safety across the department. As an update from last year, since April of 2018, the department closed over 1,300 PREA reportable cases, which includes the 1,1216 cases previously identified as the PREA backlog. There are currently 400 open PREA reportable cases that comprise the secondary backlog, which again was an expected outcome of focusing on older cases, and all of which we anticipate having closed by August 2019. As of last week, the department did not have any PREA reportable adolescent cases open older than 90 days. When the department last discussed its PREA operations, we reported that our case substantiation rate was similar to the national average. While we have reason to believe this will continue to be true of current cases, the closing out of lower priority cases from 2015 and 2016 has resulted in a lower substantiation rate for this review period. The PREA backlog was created as a result of deprioritizing closing paperwork on cases that had been identified by investigators as unlikely to be substantiated. It should not be surprising, then, that focusing on these cases led to a lower substantiation rate. Finally, I would like to note that the current national substantiation rate was produced in 2017 using data from 2015. We anticipate the Bureau of Justice Statistics will announce an updated PREA case substantiation rate in 2020 using data from 2018. We believe that upcoming figure will ultimately be more relevant in comparison for evaluating the department's substantiation rate today than one based on 2015 numbers. As the Commissioner described in her remarks, the department has greatly expanded its PREA investigations team. In the last year, the unit has nearly doubled in size, comprised of an investigations director, a trials director, a deputy director, 6 supervising investigators, 1 agency attorney, 30 investigators, and 2 data analysts. Expanding the PREA unit has allowed the department to have the resources to investigate, review, and close cases in a timely manner. Although every case is investigated within 72 hours, we know that the additional effort necessary to administratively close cases is a critical and meaningful aspect of delivering justice for victims of sexual violence and building institutional trust in the department's commitment to sexual safety. Beginning in September 2019, we anticipate that all PREA cases will be fully closed within 90 days of an allegation, unless there is an open external investigation that bars the department from doing so. In advance of this hearing, the board audited the department's unannounced PREA rounds and the PREA investigation team's closing memos. PREA unannounced rounds are a critical component of institutional sexual safety, and we are pleased that the board's audit found that in compliance with minimum standards, these rounds are happening and happening at unpredictable hours. While I will leave additional details and questions regarding the unannounced rounding practice to my colleague, Assistant Commissioner for PREA, Faye Ilardi, I do want to share that we have reviewed the board's 3 recommendations from this report, and I'm proud to say that all 3 are either already enacted or underway. In the weeks leading up to this hearing, I was pleased to have the opportunity to speak with the board staff several times about the closing memo audit. I thank you for reviewing the 18 pages of notes we sent over after your initial draft. I was glad to see some of the department's notes incorporated into the final draft. I appreciate the spirit of the collaboration with which the board approaches these reports, and the department shares your collective goal of accurate and transparent reporting. Before we move to the questions phase of this hearing, I would like to take a minute to discuss several key findings from the board's audit and offer additional explanation about the department's practices. The department takes its responsibility to separate incarcerated individuals from their alleged abuser seriously and acts expeditiously whenever possible. While we recognize that this may not always be noted in the closing memo, separation between victim or alleged victim and alleged abuser through an order of separation is standard departmental practice. While an investigator may not note the order of separation in the closing memo, it is included in the full investigation file. In previous audits, the board raised concerns about confidential interview settings. While investigators have always strived to conduct interviews confidentially, due to constraints of the jail environment, it had not been standard practice. The department took the concerns the board raised in April 2018 seriously and has since set up a system for confidential interviews. Every DOC facility now has a location set up for these interviews. While we can certainly continue to improve our operational processes, I do want to take a moment to acknowledge that where we are today in comparison to where we've been is a milestone achievement. Finally, I want to stress that this closing memo audit should only be considered just that, an audit of closing memos. It should not be confused with an audit of the quality of investigations into PREA complaints. We recognize that it is important for closing memos to be robust in their description of investigations, but ultimately they are an administrative tool that can't replace the entirety of the evidence and information within the full investigative file. Moving forward, we would welcome the opportunity to discuss the methodology of the board's audit with the board and make recommendations as to what additional information within the full investigation file should be considered during future audits. Additionally, we don't believe auditing 20 of more than 1,300 cases is an appropriate sample size for this audit type. In future audits, we do urge the board to widen its scope and evaluate a statistically significant number of cases in order to draw its conclusions. The department continues to work hard at improving the quality of its PREA investigations. The unit has thrived under a team of leaders and supervisors who have sexual assault investigative backgrounds, both on the criminal and administrative level. Moving forward, we will continue to refine our PREA investigative practices and look forward to the integration of PREA cases into the case management system, which we anticipate will be ready for use next year. I am proud to be joined this morning by Assistant Commissioner Faye Ilardi, and we are prepared to discuss any questions you may have regarding the department's continued compliance with PREA investigations at this time.
Thanks very much.
Thank you.
Anybody?
I'll start. Can you hear me? No. Hello? Can you hear me now? Yes. First, I would like to acknowledge and appreciate the, no?
Get it closer.
Hello? Yeah, I would like to, Bobby Cohen, the Board of Correction, to acknowledge and appreciate the tremendous work the department has done. This is an issue which we can't spend enough time on. It is something that's characteristic of prisons and jails. It's part of the legend, the social notion of jails are places where rape takes place, and it is very important that we address it. And I think the department, the improvement that's been demonstrated by our audits and by the Nunez audits is accurate and well deserved. So,
Thank you.
Very glad to be able to say that. I have some questions about the DOI. DOI is not here today, and which I think is too bad. We asked them to come, invited them, and they chose not to. They have given us testimony, but I don't think that's adequate because we can't ask them questions, so I have to ask you.
I'll do my best.
Well, it's very important. So, I think the commissioner stated that DOI does not delay the processing. In the Nunez report that just issued, DOI was identified as delaying processing of reports. And so, do you have numbers of cases you refer versus cases? They said there were only 23 cases that they investigated over the past several years, since the beginning of 2017 when the rule went into effect. Does that mean that there are only 23 cases that they could hold up for you? How long does it take for you to get the response back to them that they're not investigating? Because Nunez said that that often went very long.
So with respect to their clearing a case to us for investigation, that does happen pretty promptly. We advise them of what we have immediately as soon as we get a sexual abuse allegation. We advise them via email, you know, this is what we have, this is the allegation. Are we cleared to investigate, or will you be keeping it? And for the most part, they do have a quick turnaround when they reject it and send it back to us. We do get that very quickly. And it has not impacted our ability to investigate within the first 72 hours. Where they choose to take the case and investigate, you know, I can't comment on that because I'm not part of DOI, but obviously each case has its own intricacies, and it may take them, you know, a certain amount of time to conduct a criminal investigation.
The Nunez report noted that there were regular meetings held between the department and other agencies regarding cases that were being investigated by others. Do you have meetings like that with DOI?
We do. They are, we have meetings that are frequent with respect to cases that they are investigating, not only DOI, but if external district attorneys are investigating, so that we can be apprised of the status.
In the DOI response to the board, they gave 4 reasons why they would or would not take a case, among others. They said because the names of the perpetrator and the complainant were not given. That was a reason they would not take the case, and I believe that's an issue that, you know, they just didn't have the names. Mm-hmm. That there was no physical interaction, which made a lot of sense to me. That the perpetrator, in this case it was security staff, had a record of prior complaints, mm-hmm. which, and the 4th was that they did not have adequate investigators to take on the case. That's what DOI said to the Board of Correction as to why they would or would not take a case. I'm concerned about that, which you can't answer for, although we'll inquire later. But let me just give that back to you. I appreciate how much work has been done, but could you give us some back of the envelope calculation of why you think 30 investigators and the number of supervisors you have are going to get up to date? I would imagine that closing cases from 3 years ago would take less time than closing a case tomorrow. So what is the basis for? We want to make sure that you have adequate staff for this
Yes.
for this project. So what is the basis for you saying you 30 investigators and the supervisors you have is enough? DOI has told us it's not enough in their letter, that they don't have enough.
Well, we have 30 investigators just handling PREA cases alone. I'm not sure if DOI was reporting the number of investigators they have overall to handle all cases or just PREA-related cases, so I'm not sure.
They reported 40 investigators for all PREA and Nunez cases in their letter to us.
We have 30 investigators for PREA cases alone, so any sexual abuse and sexual harassment cases that come through, whether they're PREA reportable or non-PREA reportable. Plus, we have additional supervisory staff, 6 supervising investigators, a deputy director, and a director. I believe that it's not just quantity, it's quality. I believe in my team. We have very talented individuals who have been very well trained and continue to be trained. And I think that with the appropriate structure and with the appropriate leadership and with a strategy, we have been able to formulate the ability to close all of these cases in an ongoing, timely fashion coming in the future with the number of investigators and supervisors that we have. We have a very specific strategy with respect to closing the secondary small backlog by August. We have a team set up to handle, 9 of them are handling those 400 cases, while the rest of the team continues to handle the cases that are coming through. So we took a very analytical, strategic approach to this, and that is why we feel comfortable that our staff right now is able to maintain, will be able to maintain the 90-day requirement after August of this year.
Well, I hope that's the case. I think I'm going to ask sort of the calculation that you have in terms of the number of days that you think we can get something done, and how many staff you have to do it. We're going to see it with the numbers. I mean, obviously, you've done a tremendous, work on the backlog, but I just want to make sure you have enough. I have other questions, but I'd like to have other
Sure.
staff.
And I have answers to your questions from last time.
Oh, okay.
All right. I also want to echo the comments of Dr. Cohen. I've seen some really significant progress. And as Commissioner Brand indicated, your work started in 2014. I was included in some of those meetings, and I saw exactly what DOC was done before BOC became involved in rulemaking in this area. So thank you for the progress that's been made. We obviously know there's more progress to be done. I'm delighted to hear that investigations are occurring within 72 hours, but I want to focus a couple of questions on your investigations.
Yes.
And then we'll pass this around, and we'll come back to some more questions. I'll ask you a couple, and then you can just answer them. One, why are there so few allegations that are being substantiated, and how do your investigators evaluate credibility? As a former sex abuse prosecutor, I know that this is really critical to be able to evaluate the credibility. And apart from, has DOC substantiated any allegation of staff sexual abuse or abuse by a person in custody without either a video or a DNA corroboration? What other kind of physical evidence are you actually gathering within those 72 hours?
Thank you. Yes, I'll answer all of those questions. The substantiation rate is, at this time, it is low. However, it is not surprising for a few reasons. First
Can you
of
just
all,
tell us what the rate is?
Well, and I would like to address that, actually. I do think that it is not necessarily possible to calculate a rate before all of the cases are closed from that year. So, for example, the rate that the board has mentioned, or the number of cases, I think the board had mentioned that between 2017 and 2018 there had been eight cases substantiated. That might be true for the time period that you've received that information. However, because we still have 2017 and 2018 cases open, it's really not a realistic way to look at the data. For example, just since April of 2018, we have substantiated 26 PREA reportable cases. And those 26 aren't even just from 2018, they go back to 2016 and 2017 at times. And so when we talk about our substantiation rate, say from 2016 or 2017, before we're able to even close all of those cases, it's not necessarily accurate, which is why I think going forward, when we are able to keep up with the caseloads post-August of this year and we're able to close cases within 90 days, it would be a much more accurate measure to look at our substantiation rate at that time, because we'll be closing cases in real time by then, and we won't have this partial data for you. And
Let me just ask about that, though. In terms of substantiation, aren't you more likely to substantiate within a relatively short time of conducting the investigation versus ones that have been pending for months?
Yes.
Without closure? Because I would think you're not likely to substantiate those, or you would have done pretty early on. You're not
Yes.
likely to find evidence months later.
You are correct. And I think that it's a symptom of the large backlog that we had and the amount of cases that we had. And I can say that as of now, with the smaller caseloads that we have and the ability to investigate them and close them more timely, we are going to see more of that kind of pattern where we're going to be able to close those cases, especially the substantiated ones, much earlier. And so the rate is not necessarily accurate when reported because the cases weren't all closed yet. However, going forward, I think we'll have a better rate. That being said, in working with the Moss Group, and in looking at national averages and in looking at the patterns of reported cases after PREA is implemented, we do see that it is not uncommon for the number of allegations to rise, but the substantiation rate not to rise in kind. That is not uncommon, and it's not just happening here, it's happening nationally. And I am curious to see what the reports will be like in 2020 when they evaluate the 2018 cases, the more recent cases. I think at that time it would be a better time period to really calculate where we're at with respect to the substantiation rate. I also share your concern as a former sex crimes prosecutor myself. And I take these issues extraordinarily seriously to make sure that our investigators are evaluating credibility in the appropriate fashion and not only relying on physical evidence. I've tried many a case, and been able to prove cases beyond a reasonable doubt without DNA evidence and without video. And our standard is preponderance of evidence. So I completely agree with you. We will use everything in our power to evaluate credibility, consistency, corroborating evidence, whether it's testimonial, physical, or forensic. We take all of that into consideration. I will say, though, that because of the fact that the facilities do have a lot of video coverage, it oftentimes is rare to have a case where we don't have some video. Even if it's not video of the act itself, there is oftentimes corroborating video that could support substantiation, such as, maybe we don't see the act itself, but we do see that the staff member and the incarcerated individual were standing together immediately prior to the incident, and that is captured on video. So we do try to take everything that we can, including physical evidence, into account when we consider substantiating, unsubstantiating, or unfounding cases.
Okay, what about the establishment of crime scenes? We understand that that's been an issue. What's been the problem with that?
So I think the issue that the board has mentioned is not about the establishment of the crime scene, but just about the documentation in our closing memos regarding why a crime scene would or would not be set up. The cases that were reviewed, the 20 cases that were reviewed, there wasn't a crime scene necessary to set up on those kinds of cases. And I don't think the board necessarily disagreed with that, but the board's concern is we just have to get better at documenting why we're not setting up the crime scene. And that message has been duly noted, and we will be improving our closing memos with respect to documenting why. For the most part, the reason why is there wouldn't be evidence to collect.
Okay, and just can you kind of itemize some of the other corroborating evidence that you all actually do look for?
Yes.
And find when these are timely reported?
Sure.
The sex abuse in particular?
Absolutely. So obviously Genetech video is very important, but also we review phone calls that are made by the incarcerated individual, the alleged victim, as well as other potential witnesses. We also conduct interviews of the incarcerated individual, as well as if there is any possibility that there were witnesses to the event, we will interview those witnesses as well, as long as they are willing to cooperate with us. We conduct interviews of staff members as well, whether it's the alleged perpetrator or other staff members who may have been a witness to this situation. So we do collect testimonial evidence, and of course, if there's ever any allegation of anything that would develop any forensic evidence, we would absolutely collect forensic evidence, whether it be swabs or collecting physical evidence such as clothing or sheets, bedding, things of that nature, to be analyzed by OCME for DNA. So,
And one last question before I pass this along.
Sure.
Thank you so much for answering
No
the
problem.
questions. Is the interviewing that's being conducted, is this trauma-informed interviewing, and are the victims given an opportunity to have a victim advocate present with them during the interviewing?
The trauma, and I'm glad you raised that. We had sent 4 of our investigators for the FETI training, the Forensic Experiential Trauma Interview Training, and we were incredibly impressed by that training. I think anybody who knows anything about interviewing potential victims who've been through trauma knows that this training is very highly regarded. And so our department is working to get all of our PREA investigators trained in FETI training, and also potentially even get trained to become FETI trainers so that we can continue to do that in-house. That being said, every single one of our PREA investigators are already exposed to and have already been trained in taking interviews for victims of who've been involved in trauma. But we do believe in giving as much training as possible, especially of the high quality that FETI provides. And so that is something we are very involved in.
And in terms of opportunity and access to a victim advocate?
I don't know if that's I'm sorry, go ahead, Faye. I'm going to give that to my colleague.
So, Hi, good morning. My name is Faye Lardy, Assistant Commissioner for PREA. We do have a MOU, Memorandum of Understanding with Safe Horizon, and we make sure that they have that information. It's on the posters that we have inside the facilities, and also CHS has their sexual abuse advocacy program.
Could you, thank you. First, I want to also acknowledge the commitment and the progress that the department has been making on this issue. There's no question that the way the department has been pursuing working on this issue, it's clear that there's a commitment there, and we're going to see some light at the end of this tunnel.
Thank you.
So thank you for your work. But I want to understand sort of the relationship between the Department of Corrections and DOI. Do all complaints go to DOI? Right, so that's one question. The second part is, once DOI decides to keep a complaint and do the investigation, are you informed of their progress? Are you in the loop on the investigation? And the third one is, what are you doing when those allegations come up? Being that 70% of the allegations are staff on detainee, what are you doing to ensure the safety of the person leveraging the complaint and staff?
Thank you. So every single sexual abuse allegation that comes to us immediately gets referred to the Department of Investigation to see if they want to take that case or if they want to clear it back to us to investigate. Even if they do clear it back to us for investigation, if during our investigation we uncover criminality, we will refer it either to the DA's office or also to the Department of Investigation, refer it back to them to let them know. So that, yes, we do refer every single sex abuse case. And are we informed of progress? We do try to maintain a good relationship with DOI and make sure that we are informed of the progress. Now, in the interim, when a case is being investigated criminally, we stand down. We are told to stand down from our investigation. It makes sense. We don't want to step on any toes. We don't want to impede on a criminal investigation, certainly. And so we do stand down. But in the interim, we will take safety precautions. The individual will be modified with no inmate contact during that process so that we can make sure that there is no potential risk to anybody if they are going to substantiate criminality with that individual. And then after the investigation takes place by DOI, they will make a decision whether they want to refer the case criminally to the district attorney's office or if they want to give it back to us for administrative charges or both. We have a zero tolerance policy. Sexual abuse cases that come to us substantiated from DOI, we don't negotiate. That person either has to resign or we will take them to trial and seek termination. So that's how we manage that.
Can I just ask a follow-up? How many
Yes.
staff have been terminated as a result of substantiated sexual abuse?
So every
You said that's your policy.
Yes.
So how many have that?
So every single individual, every single case that has come to us, sexual assault that has been substantiated from DOI, the individual either has resigned, which is what essentially we have an opportunity to say, listen, you can either agree to just go or we're going to seek your termination. We cannot terminate without going through a judicial process. So they have that option. They can resign, or they've been terminated after an oath trial, or at times they will leave with charges pending. We can't necessarily prevent that, but they will leave the department if they know that we are going to seek their termination. It's possible that they will leave. What happens there is we defer prosecution so that if they ever try to come back, we reopen the case and we will seek their termination.
How many?
All of them have
Yeah, but
resulted.
what's the number? That's what she's looking
Okay.
for.
Oh, I'm sorry. I'll give you that number. Just 1 second. So we've had 5 individuals resign during the criminal investigation, which means they resigned while DOI and/or the district attorney were investigating them. We had 4 individuals who resigned with charges pending with us, DOC. And we have had 2 people terminated after trial. Now, I actually think that, it's not me.
He's doing it.
I would like to give an example of our zero tolerance policy with respect to this. We had a case last year where there was an individual who was charged with grabbing the testicles of an incarcerated inmate and using homophobic slurs to that inmate. The individual refused to resign, and we took the case to trial at oath, and we sought termination. We were successful in proving the individual's guilt. The oath judge stated that in all respects, the individual was found guilty. However, the oath judge is allowed to have a recommendation at the end of that with respect to appropriate discipline. And the oath judge did not terminate. The oath judge stated that there should be a certain number of compensatory days docked from this individual and that that would be the appropriate discipline. Our commissioner terminated that individual over that oath decision, and the individual appealed the termination, and we were successful at the appeal and were able to keep the individual terminated. And I think that that is a great example of our commitment to zero tolerance for these kinds of cases.
Thanks.
No other questions? I'll go again.
Yeah, Jackie, yeah, go ahead.
I got this one. Thank you. I'd like to join my colleagues in acknowledging the progress and commitment of the department to making further progress on full implementation. And I'd like to hear more about the department's reaction to response to the audit on unannounced supervisory rounds.
Yes. I'll defer to my colleague.
Thank you.
Just on that same question, I had a similar question, and that is, I think it was reported somewhere that the logbook that records those rounds sometimes contains false information in that a certain number of the logs that are recorded, the actual related round never took place. In other words, the logbook would record a round, but the round itself actually never occurred. And so in following up with Jackie's question, I would just be curious to know what the department's response to that particular problem might be.
Okay. So thank you. Thank you for bringing that up. And we also would like to thank the board for bringing that to our attention. So we received 20, I believe, from the board indicating that the rounds were indicated in the logbook but had not taken place. And so out of the 20, we gave corrective interviews. We had to give verbal because the allegation was over 30 days. We also realized that out of the 20, when we looked at the Genetec, 4 of the rounds had actually been done. And we can discuss that with the board at a later time. But also, the chief made sure to put out another teletype emphasizing the importance of the unannounced rounds, right? We also took the board's recommendations, and we're going to implement those recommendations. And I'm glad to say that one of those recommendations we were already in the process of doing, which was revising the PREA directive to include the unannounced rounds in there to give staff additional direction on how important the unannounced rounds are and what they consist of. And so in the teletype, we reiterated, and it just went out last week, that the tours have to be done and they have to be conducted at least once every shift. And the tours need to indicate or ensure that all the doors and all the windows of the cells are not covered. We need to make sure that if there's any area that's not seen by the officer or on camera, which we don't have many of, I'm glad to also announce, that staff needs to go into those areas to make sure there's no inappropriate activity going on in those areas. Continue with the tours being unannounced. And also we're implementing our own internal audit process that every 2 weeks, somebody needs to go around, our PCMs, our PREA compliance managers, and our PREA ambassadors already do an audit of the logbook, but in addition to the logbook, we are also working with the chief to have access, some of those individuals to have access to Genetec, to do what the board did, look at the logbook and also check Genetec. And we plan on doing that every 2 weeks to ensure compliance with the unannounced rounds, because they're very important.
You know, for me, there's two issues here. For me, there's two issues here. One is whether or not the rounds are actually conducted, but the second is falsifying the logbook records. So, frankly, I think that may be a more serious problem for me, that the records are it seems to me the records are deliberately falsified. So, I just would suggest that that's an area that where some additional concern.
We are looking into that, and like I said, there were some command disciplines given to staff, and also the teletype also warrants and let them know that if warranted, disciplinary action will be given to staff members who do that. And I believe the chief wants to add to that.
Yes, hi, good morning. Hazel Jennings, Chief of the Department. So in conjunction to looking at video, we will be doing our own internal monitoring. We're also going to be doing a robust training in reference to the unannounced rounds with our supervisors that we meet with bi-weekly. And we're going to be tasking our video monitoring unit, which we established in 2018, with looking at video just specifically in reference to PREA. So staff will be reminded that if they fail to do the unannounced round and they're just making logbook entries, there will be discipline associated with that. Okay?
Can I just follow up with a question on how the department uses the findings from rounds that have been conducted, and whether there are plans to enhance any process that is currently in existence to use findings from rounds to drive further safety improvements?
So like we said, what we're going to do is, on top of looking at the logbooks, we are going to also look at Genetec, the PREA unit, our additional unit who has the Genetec. I'm sorry, you're shaking your head. Am I not answering? I'm sorry.
Well, my question is more focused on the findings from rounds. I understand the improvements to the internal audit process, but based on what is found, what has been found in rounds to date, and anticipated future information, how will the department and how does the department use the information that is generated from the rounds to drive practice improvement?
My apologies, I didn't understand the question. So what we found in our unannounced rounds was a lot of times the incarcerated individuals would have the cell doors or the cell windows blocked, right? Because they want additional privacy. We have to emphasize to staff, and we have been and going to continue to emphasize to staff, that that cannot happen. And so we use the unannounced rounds and the findings of the unannounced rounds to tell staff, listen, make sure we tell the incarcerated individuals to remove those items that might be blocking cell doors, that might be blocking windows, to give us a clear view inside of the cell area to make sure that there's nothing inappropriate going on.
We're going to have to just interrupt the schedule here for a bit. We need to call up the Bronx DA now, and we'll come back to the department when we...
Can I just ask one question before we do that? Hi, good morning. Welcome back.
Thank you.
I just had a question for the Bronx DA, about the Bronx DA. So you talked, and you're doing a terrific job. You know, Bits reported to me at the fire department, and I know the size of the crowd that they have, and I know to have the head count that you've secured is an incredible bureaucratic success, right? It's just unbelievable. What I'd like to understand is DOI. If you see evidence of criminality, can you go right to the DA? If DOI takes a pass and says, particularly given their comments here where they say they took a pass because there was no name attached, right? That to me is ridiculous. So do you have the wherewithal under the protocols, you have to just go right to the DA and talk to the DA about it.
Yes.
Okay, thank you. I wanted that question before the DA came and talked to us.
No pressure.
Thank you.
Good morning, D.A. Clark.
Good morning. All right. Thank you for changing the schedule and allowing me to speak first. I have another engagement that I have to go to that I was committed to before I knew about this hearing. So again, I apologize for that, and thank you for giving me this opportunity to appear before you, especially during this month of April, which is Sexual Assault Awareness Month, to discuss the successes, the challenges, and the recommendations in the area of preventing and responding to sexual abuse and sexual harassment in New York City jails. Since I became DA with jurisdiction over Rikers Island jails, I have said time and time again that I will not tolerate any type of violence or sexual abuse by detainees or inmates against each other, by staff against inmates, or by inmates on staff. I have vowed to prosecute anyone who perpetrates such crimes in the jails, and I carry out that pledge by committing the resources to investigate and bring charges for crimes that we can prove in a court of law. In March of 2016, I formed the Rikers Island Prosecution Bureau, as you well know, for detainee crimes, and I also established the Public Integrity Bureau for crimes by staff at Rikers. Now, prior to the establishment of these bureaus, various sex crimes prosecutors handled the allegations in the jails. With the establishment of the Rikers and the Public Integrity Bureaus, the handling of these cases is now centralized, and the ADAs that are doing these cases now have more experience prosecuting crimes that are committed in a correctional facility. And I want to highlight some of the prosecutions, or some of the more successful ones that we've had since I've been in office the last 3 years. We did bring a 100-count indictment against an inmate by the name of Alexandria James, who sexually abused a woman while using a makeshift phylactic device in a segregated cell in Rose M. Singer Center. And she also physically assaulted 2 other women in the facility. We received a letter from one of the assaulted women after she was released from jail. And the letter was addressed directly to me, so I received it. And I immediately turned it over to my team. We acted immediately to initiate an investigation. But the investigation took months because it required, of course, reviewing extensive video evidence, as well as interviewing other detainees in a way that had to provide security so that we could earn their trust in order to get the information that we needed. Ms. James did plead guilty in 2018 to aggravated sexual abuse and other charges, and is serving 6.5 to 8 years in prison for that. We also had a case of now a former corrections officer, Jose Cosme, who was charged with engaging in sexual conduct with a female detainee in 2015. He pleaded guilty to criminal sex act in the 3rd degree, a Class E felony, and was sentenced to 10 years probation, and he has now been required to register as a sex offender. A trial is set this coming June for a case of Sidney Wilson, who is a physician's assistant who worked at DOC for the former contractor Corizon in the clinic. And our office is ready to present evidence that Wilson engaged in 38 counts, including 3rd-degree rape, sex abuse, and criminal sex act, allegedly committed against 4 female patients spanning over 18 months. Again, it was an intensive investigation that took more than a year. 3 of the detainees were incarcerated in Albion Prison, which is in New York State, up near the Canadian border. And the case required a lot of resources for us to get it ready for trial. We interviewed the victims upstate during their incarceration. a crime victim advocate works with them now that they've all been released and is helping us to prepare them for the trial. Now, I also understand that the Legal Aid Society has brought a case to your attention, questioning my office handling of a particular case, of that case. So while I can't specifically address current investigations, I can tell you that the Public Integrity Bureau has a very active investigation ongoing of that matter that Legal Aid referred to you. It started in August 2016 when we were referred to the case by DOI. It involves allegations against a DOC officer of misconduct of a sexual nature. We take all allegations of sex abuse seriously and are acutely aware of the sensitive nature of these allegations, especially in a jail setting. Detainees fear retaliation, and an incarcerated victim suffers another layer of trauma because he or she cannot leave the place where the assault occurred. And other detainees live in fear if the sexual abuse seemingly goes unchecked. But these cases are complicated and sometimes very difficult to make. But difficulty doesn't mean impossible. And just because it's hard doesn't mean that we don't do it. But we have to be deliberate and make sure that we investigate well, not to just bring a case, but to make sure that we could bring a case that's really going to bring justice for the victims and fairness for the person who is accused. The burden of proof is lower for DOC's internal investigations. Of course, they deal with the preponderance of the evidence, but we have to prove a case beyond a reasonable doubt, a much higher standard. So since 2016, the Rikers Bureau handled 30 arrests involving sexual criminal conduct. 2 were felonies, including the James case that I mentioned earlier, and a conviction for another defendant who pleaded guilty to persistent sex abuse, resulting in a 3-year prison term. The other 28 cases were for forcible touching of staff and public lewdness. Public Integrity has prosecuted 8 cases of sexual abuse involving staff against detainees. We have many challenges in these prosecutions as well. The detainee victims, again, are reluctant to come forward while they're incarcerated. And of course, there are some credibility issues with the victims as well as the witnesses. A detainee can accuse an officer and then and we found this, that their allegations have been made, and then as we continue with the investigation, we find evidence that the act was done so that the person could bring a lawsuit or something like that, or, that some of the facts are exaggerated in order to seek out a settlement. Now, this is not to victim blame. This is just the reality of what we find when we do investigate the cases. But that doesn't mean that we're not going to go forward as well. A lot of times the detainees' attorneys will tell the media that we did nothing or that my office was unwilling to do anything. And in reality, what happens is that they choose not to cooperate with the criminal investigation. They choose to deal with the civil litigation that comes along with it, and it doesn't help me because as you know, I need victims to come forward. And we have to have the victims come forward, especially in cases where there is no video or there is no physical evidence, or we have reluctant witnesses that want to come forward to cooperate. So even though there are numerous cameras in the jail, of course, the sex abuse, of course, usually happens in places where there are no cameras, and for obvious reasons, so that it cannot be captured. Sometimes in bathrooms, pantry areas, closets, kitchen areas, etc. But again, it doesn't mean that there is not some evidence of it. It may not show the act, but there may be video in other ways, so we can try to put things together. But usually, you don't get the act on video. But I'm going to return to this later in my testimony about that. But if a detainee has been raped or sexual violence against them, the opportunity for the evidence is stalled or lost because a sexual assault forensic exam is not performed immediately. What it comes down to is this. I know that as a board, you are focused on the slashings and the serious physical assaults. We have made priorities of that, and I've testified before you before as to those issues. What we now need to do is prioritize these sexual assaults. I'm glad I was here to be able to hear some of the testimony of the department to see what progress there is done. You know, we can't do these things in silos and vacuums. We have to communicate with each other to really know what's going on. So I'm glad that I was able to hear that. So in prioritizing those things or having more open lines of communication, I have some other recommendations I think that will help improve investigations so we could move forward with the cases that I do receive the recommendations about. First of all, it has to start with a safe place for a detainee to report abuse. There needs to be an atmosphere of confidentiality, discretion, with privacy from other inmates and staff. There also needs to be immediate forensic exams. Sexual assault evidence collection experts should be doing the exam on site to speed up the investigation process and preserve vital corroboration. It should be a required procedural step. I don't know if it is or not, but I know plenty of times we get the cases and it wasn't done early. We need a consistent, fixed protocol to handle allegations. Now, I'm glad I was here to hear the department testify, and I know about the minimum standards. We need to be more in tune with that. There needs to be some more collaboration as to how these interviews happen, the exchanging of the reports and things like that. So we know ahead of time, when by the time the DA's office get it, it's like you said, the department goes through an investigation, DOI goes through an investigation, and then DOI gives it to us, which means that we have to look at everything and sometimes start all over because so much time has passed by. So we do have to deal with a more consistent protocol that's going to be able to thoroughly be able to handle these allegations in the right way. And we need, of course, faster notification to us. There's been instances where we didn't know of a rape in Rikers for weeks or even months afterwards, only finding out because the staff member in our office responsible for lab results was notified about a positive DNA finding from a rape kit generated at Rikers some months earlier. So we don't know. Of course, we need more surveillance cameras everywhere. And I know there's a lot of cameras there now, but this is for the protection of the accuser as well as the accused. Sensitive cameras with limited access can be in areas of the jail. Our burden of proof is beyond reasonable doubt, and if an inmate is fabricating allegations, we can quickly determine that if we have the video. So more, and when we say more sensitive video, meaning that it's not going to be for everyone to see. There's certain sensitive areas now that they have video. We need more in certain places so that we can be able to monitor, or the department can monitor to make sure that these sexual acts are not happening. DOC intelligence gatherers focus on contraband and violence. Perhaps more training they need to obtain more information about sexual abuse in the jails during their monitoring of the detainees. So again, more training for DOC staff. That's key in anything that they have to do, especially the investigators. So the more training, the better. And then lastly, I want to encourage these attorneys that represent victims of sexual abuse in the jail, that they need to cooperate with us in these criminal cases. I'm tired of being accused of not doing my job when I can't do it if they don't allow their clients to come and speak to me. I don't know if they think that it's going to hurt the civil case if there is one, because I find out a lot of them sometimes when the civil suit is in the paper. So I immediately go to my team and say, wait a minute, did we look at this? And of course, when we look, I say, yes, we did, but come to find out that the lawyers wouldn't allow the witnesses or the victims to come forward to speak to us, to cooperate, so that we could bring charges. Again, it's not easy to make the cases, but just because it's not easy and it's hard doesn't mean that I won't do it. You know, just because it's difficult doesn't mean I'm not going to do it. I know I have a job to do, and it's a tough job, but this is serious. This is very serious. So I want to continue to be a force in those jails to make sure that these crimes don't happen, just like all the other crimes that I have concentrated on to make sure that they don't happen in the jails. and I stand ready to work with all those who have a stake in improving the safety in our jails. Please be assured that we believe no one should be subjected to sexual violence. A person behind bars is a human being. They should be treated humanely. They deserve the same dignity, compassion, and vigorous effort from my office as anyone else in the community. I believe I've answered some of your concerns, but I welcome any questions that you have.
Thank you very much. Any questions or comments from the board? Thanks so much. Appreciate it. Judge Hamill.
Thank you so much for coming to speak to us. I know firsthand about the work of the Bronx DAs
Yes,
because that's
I know.
where I worked. And I know the standard, for a criminal investigation, for a criminal prosecution, beyond a reasonable doubt. First of all, you've answered a lot of the questions that I had, but I just want to go into a little bit of depth on some of the recommendations you made, and thank you so much. I also want to thank your office. When this board was in the midst of PREA rulemaking, we met with your team, executive staff, and some of your investigators and prosecutors. It was very helpful to our rulemaking.
Thank you.
You gave a lot of recommendations for improvement here, and obviously the level at which you prosecute is much higher than the administrative matters at DOC. Can you be specific in terms of your recommendation that they need more training investigations? Can you tell us where, and this is in the spirit of collaboration, not criticism, we all have the exact same shared goal here, where in particular you're seeing some weaknesses and challenges in their investigations?
Well, I think the evidence gathering is a big part. I think that the interviewing techniques, and these are some of the things that they've already talked about in training them how to interview witnesses better. I think that they're understanding the burdens of proof, that there's a difference between one and another and the other is important. I just think overall that, when I first took this job and we began doing the violence cases and stuff, one of the most glaring things that I saw is, one, they didn't have enough staff doing the work that needed to be done to investigate it. And then two, that the training that they received was not the kind of training that they understood how to build a case so that it could be prosecuted. So there's one thing for the administrative process, and there's another for the criminal process, as you well know, Judge Hamill. So again, I think it's just reinforcing and educating the investigators on what is going to be admissible, what type of evidence are we looking for in order to bring a successful prosecution. So it's little things like that, and the technical part of it as well. But I just think the more training, the better. Whether it's my office helping to do that, which we're always willing to do, or the FETI training, the people in my office have received that, but they've had a lot of trauma, interviewing training besides the FETI one. So, we do this. So the better that we can collaborate, I think, the better the cases we'll be able to build.
Well, and thank you for offering to do the training, because if they're doing the investigations, and this is in your jurisdiction, the Bronx, to the extent you can help train their staff, you'll get cases better presented for your prosecution. I did just want to, I've forgotten some of my criminal law, but if I recall, the statements that are made to the DOC investigators or statements to law enforcement, so that's Rosario material that has to be turned over, and if they're not well trained on interviewing, then they may obtain statements that may appear to be a little bit misleading and may appear to be inconsistent with statements you may ultimately get. And that's why it's so critical that the investigators really truly know how to interview for a proper criminal investigation.
And it also
prosecution.
depends on who the investigator is interviewing, because
Yes.
there are different rules for, DOC staff being interviewed by DOI. DOI is the oversight agency for DOC. So therefore, when they take interviews from them, it's compulsory. They have to answer, and we're not allowed in criminal trials sometimes to use that type of evidence. So you have to separate things. So there's a lot involved in that. So we want to really, make sure that they understand that in bringing, in doing the interviews and bringing the building the cases that we need.
Thank you.
Thank you, District Attorney, for your work. 30 arrests, clearly your zero tolerance is in effect. You have a bureau out there on Rikers so you can respond swiftly, and you're taking these cases seriously. But have you worked with the Department of Correction? 30 arrests could be a way of sharing that information during training for officers coming on about what will happen if officers engage in inappropriate sexual contact with people detained. Have you and the department worked together to put together a sort of media public campaign for some of the officers so that they know how your office is going to approach these kinds of issues?
I don't know if we per se have done some actual training. That's something that we can always do. But I think that, I set an example by unfortunately having to indict some of those and going through it, that the message, is related there. But I also have to say I do work with the unions for DOC, and we talk a lot about some of the things that I have to do. And I know that, it's been a real progress, but one that has been positive in my opinion, because when we first started, it's just, things weren't working well. And it's not until you begin to work with people and they work with you that they can understand that we all share the same goal. So therefore, and a lot of it was miseducation. Like, I just assumed they knew things and they just assumed I was doing things. But once you got to talk and understand, we're able to educate each other on the work that we do. So the relationship is a lot better. And I know that the unions don't want officers or staff that are going to, disgrace the badge. They don't want them there they're gonna cause harm in the jails, that's gonna hurt other officers because they are doing illegal things. So that we continue to do that, but that is something that I think that can easily be done. Just as we've done with, report taking, that was, it was outrageous, some of the reports we were getting, and, it was like falsifying documents and things like that. And I don't want to have to prosecute somebody to teach them how to do that. But after I did a couple of them, it's like, you know what? I'm not going to be able to prosecute my way out of this particular problem. We need to just talk and discuss. And once we did, I know they started training their staff. Look, don't do this. This is wrong. If you do this, this is what's going to happen. So this is the very type of thing that we can also do with these sexual cases.
Great. Dr. Cohen.
Yes, thank you very much, Mr. Attorney. I have two questions. I don't think you've answered them yet, although your testimony was very, very helpful. One is numbers. Numbers of cases since you've been district attorney, or since the board standards began, January 17, who have been referred from DOI to you for investigation, or or from DOC for investigation, both for staff and persons living in prison as the perpetrators. And my second question has to do with coordination. You mentioned your concern that you hear about things too late, and the process is. Well, it's sort of defined, but not. It sounds like there may be improvements in terms of collaboration. So, is there a process where you and DOI and DOC and perhaps even the other district attorneys meet regularly on possible investigations, so that there's a list of people who have made complaints which have been judged good enough to go to DOI or there, et cetera? So those two questions, one on quantity and one on collaboration.
I'll answer the second one first. I do speak regularly with DOI, with Commissioner Peters before he left, and now with Commissioner Garnett. And we, as the head of both agencies, speak once a month with the list of the cases, the force cases, the PREA cases, certain cases that have to do with DOI and their investigation. So for the purpose of corrections, it would be the PREA and the use of force cases. And we go through the current investigations that are happening. We talk about those that have been lingering, what is the goal in a particular case. So we do speak regularly about that, but of course, it's after we've received the referral from them. And part of some of those conversations were like, you saying that I'm taking a long time doing it, but remember, you didn't give it to me until very late. So we have that monthly call just so that we can stay on top of those things. Our teams also meet, speak weekly, and they also meet in order to make sure we try to stay on top of those things. I think that's how we got through some of the improvements that we have been able to make, is because we've had that dialogue. As far as with these particular type cases, again, I'm happy that I was here to hear the testimony of DOC, because I do see some places where we can collaborate, collaborate in order to get some of the information to help us speed up some of the investigations as well. Sharing some of the things that I've heard them talk about, asking my team, do we get that? When do we get it? How do we get it? Things like that. So, being in a room hearing this is helpful for us to understand how we can do it better. So I think that, we will actually be able to do that. As far as how many cases we received since 2017, I have 19 cases that are all sexual assaults by detainees. And this includes detainees on staff that are not necessarily PREA cases. And then we have 4 cases of staff on detainees or inmates, and we have 6 pending investigations with some of those defendants. So those are some of the...
Those came from DOI or from DOC?
Usually they come from both. They come from both. Some from DOI, some from DOC. That's it? Good, good, good. All right. Anything else? No? Thank you for the opportunity.
Thank you very much.
Thank you.
We're going to now hear from the Manhattan DA's office. Thank you, District Attorney Clark.
Good morning, Chairman and members of the board. My name is Vanessa Puzio, and I'm a supervising attorney in the Sex Crimes Unit at the Manhattan District Attorney's Office, and the attorney in charge of the work-related sexual violence initiatives. Thank you for the opportunity to have us speak here today about DA Vance's strategies to combat sexual violence in the workplace, specifically within the New York City Department of Corrections. Recently, our office received a letter from an anonymous group of female corrections officers. The letter detailed sexual harassment and sexual abuse within the Department of Corrections. Specifically, the letter detailed sexual misconduct committed by supervisors against female staff. It was anonymous, but the writer made it clear that she and other female officers needed help. After reading the letter, I reached out to the Corrections Officer Benevolent Association Union and was subsequently invited to Manhattan Detention Complex to give a training on sex crimes in the workplace. The overwhelming majority of officers that I spoke to that day stated that inmates routinely groped and touched both male and female officers. The sentiment amongst the corrections officers I spoke to at Manhattan Detention Complex was that being touched in a sexual way had become, quote, part of the job, and reporting it in-house was, quote, not worth it. I urged the officers not simply to consider reporting in-house, but to also report directly to us, to law enforcement. I spoke to them also about potential sex offender registration. Clearly, there are significant challenges for corrections that are not necessarily reflected in the number of sexual assault cases that are reported by or against corrections officers at the Manhattan Detention Complex. For example, in 2018, there were 597 post-arrest sex crimes cases handled by our office. Out of those, 0 were from Manhattan Detention Complex. In 2017, we again had 0 sex crimes cases originating out of MDC. Not one sexual assault committed against a corrections officer, not one sexual assault committed by a corrections officer. There is also a dearth of complaints that come to our office concerning sexual assaults where inmates are the victim and the perpetrator is also an inmate. As stated in your audit, these cases are occurring and being reported to in-house investigators, but they are not making their way to our office. And I'm here to ask the question, why is that? Under the current system, when an individual reports a sexual assault involving a corrections officer, the case is done and investigated, as we heard today, by in-house investigators. As seen in the New York City Department of Corrections audit report, these investigations are not always being done in a thorough manner, and cases are forwarded to DOI. But if the initial investigation is not being done thoroughly, the victim in that case is never given an opportunity to have law enforcement appropriately investigate his or her case. To us, the current system at corrections for PREA cases is reminiscent of the now reformed system at colleges and universities, where victims' complaints were dealt with simply in-house, and where victims of sexual assault were not given options immediately on reporting directly to the DA's office and to law enforcement. Victims of a sex crime should not only be given access to medical care as mandated in your rules, but information and swift access to law enforcement. Sexual violence is a devastating crime that leaves a lasting impact on the survivor. The impact can be acutely felt when the sexual abuse is suffered at the workplace. The Manhattan District Attorney's Office is committed to investigating and prosecuting these crimes and to achieve justice. In the wake of #MeToo, our office saw not only a spike in reporting of sex crimes cases, but countless media reports detailing sexual abuse. In an effort to encourage further reporting and engage survivors, the Manhattan DA created the first of its kind work-related sexual violence unit. The unit recognizes the inherent power imbalance and fear of reprisal that survivors face in reporting. But when an act of work-related sexual misconduct constitutes a crime, it is not enough that the abuser loses his or her job. Justice demands and survivors deserve that criminal abusers be held accountable in court. DA Vance asked me to lead this work-related sexual violence unit, with our main goal being to encourage further reporting. As a prosecutor, I continue to work directly with victims of violence, but I also go out into the community to speak about our office and encourage further reporting. We contact businesses and organizations directly and ask them to circulate our materials to members and employees. We also offer trainings to employees, to members of associations, to let them know who we are and what we can do to help in terms of referrals or in-house counseling. We consider this a more holistic approach in dealing with sexual violence. When I went to Manhattan Detention Complex, I gave out our hotline number and our materials, and I stressed that we're not just a faceless telephone number at a government agency. We are there to answer questions and provide support for victims of sexual violence. I would suggest that going forward, our office, as DA Clark said, be brought to the table and that there be further collaboration to assist officers, to assist survivors at Manhattan Detention Complex with information so that they can make informed decisions about reporting acts of sexual misconduct to law enforcement, to follow through on those complaints and to see some real change. Furthermore, anyone reporting a crime that falls within PREA within a correctional facility should be also given the information and resources to have their case investigated directly by us immediately and not be left to the discretion of in-house investigators. Thank you.
Thanks very much. Questions or comments from?
Thank you so much for coming to speak to us, and thank you so much for your comments. Much of this, in terms of what's going on in Manhattan, it's certainly new to me, and certainly before you leave, I think we need to ask DOC, why is it that no cases are being referred to you? But I want to ask about a separate issue that you haven't mentioned. We hear from a number of lawyers, and we hear from a number of advocates that there is an issue with respect to searching of visitors when they come to visit incarcerated persons, primarily out at Rikers, but I don't know if it's an issue in Manhattan or not. Has that come to your attention at all? any allegations of visitors feeling that they were inappropriately touched or searched when they were trying to visit a detainee in Manhattan House?
No, it has not. We have not received any of those complaints.
Okay, and I'm going to ask you the same question that I asked DA Clark. Can you tell us from your perspective what could be improved in terms of the DOC's investigations? And if I understand you correctly, what you're saying is you'd rather these cases be referred immediately so that you can investigate them yourselves without having to wait, because time is of the essence in these cases. But to the extent that they do investigate, if you can share what you believe some of the challenges have been and what could be improved.
Of course. So that would be our goal. That would be our preferred method, would be that it would be immediately brought to our attention at the DA's office. If that doesn't happen, I think we want to be brought to the table. The numbers speak for themselves. We are not being brought into this conversation at all. And so we would like further collaboration in terms of being kept apprised of what investigations are pending. We would also like to be involved more in trainings. We are more than happy to speak with other DA's offices or go to Manhattan Detention Complex regularly to help with training so that we can better build, just as DA Clark said, build cases rather than look to close cases.
When the board, thank you very much for coming today, really appreciate it. When the board developed its PREA rule, we had an internal debate about who should do investigations. There was a question, which still is a question to me, based on, it's not changed based upon what we've heard right now, which is that it's very difficult for someone to investigate themselves. And that I wish the department did not have the responsibility to do investigations, because I think it's almost, it's very, very difficult to find internal fault. City law requires the city charter requires every criminal act that happens on Rikers Island or in Manhattan House of Detention to be reported to DOI. Are you suggesting, and I would support it, I think, that at the same time that a DOI report is made, that the Manhattan DA be reported on anything which is thought to be a possible criminal activity?
Yes, we're suggesting a simultaneous reporting system so that we are reported to along with DOI.
Do you think we didn't get a chance to ask DA Clark about it. Do you think that the other DAs would want that kind of reporting?
I don't want to speak for other DA's offices, but, we are at an advantage in terms of our proximity also to Manhattan Detention Complex, and that it is not extremely large, so we would be able to have the resources to do that.
Well, the Bronx DAs have staff, on Rikers Island right now. I think one of the things that this raises, just for the board to consider, is the need for a process that has all of these state agencies, perhaps even the Southern District, as well as the Bronx and Manhattan, Brooklyn, and Queens DAs working together on these issues.
And I don't know if thank you for coming and presenting. I don't know if you can talk about an open investigation, but it sounds like you talked about receiving a letter that was about sexual harassment of supervisors, and then there was a contact with the union and training for staff. Has the department been made aware of that allegation? Is that a pending investigation?
My understanding is that it's not a pending investigation because the people in the letter would not name themselves. And so it was sort of brought to us, and then there was the question of, well, what do we do? What can we do? So that's when we contacted the union and said, we received this letter. What can we do to help in any way? And their idea was to bring us to MDC to give a training.
And maybe the department might want to hear about it.
Well, while you're here, I think we need to ask, I don't know, Commissioner Brand, if you want to answer the questions, or someone else. We all want to work together. We all have this shared goal here, right? And I think what you're recommending sounds to be very reasonable. So Commissioner Brand, or whoever staff you want to delegate to, what do you think about this idea of any type of alleged criminal activity that occurs at Manhattan House? Obviously, it's a much smaller jail than Rikers. And I could see where maybe DA Clark wouldn't want everything referred to her office. She has limited resources too, but with Manhattan being so small, I can see why you would want that. And you know, being involved at the beginning is critical to making a good case. So Commissioner Brand?
Thank you for the opportunity to respond. We were not made aware of that anonymous complaint at MDC and would have appreciated knowing about that. And neither the union nor the DA's office let us know that they had been there or had conducted any training. So I will address that. With regard to notifying the district attorney's office, we are under charter responsibility to report to DOI. And then if they give us back something, we can afterwards go to the DA's office if DOI declines the case. However, each district attorney's office gets the cases from their own jurisdiction. So we would not sit with all the district attorneys and discuss all the cases originating in different jurisdictions.
Right. Maybe I'm mistaken, but I thought someone said that even with the Bronx cases, the cases that occur out at Rikers, that sometimes they're of such an allegation that they do get referred to the district attorney's office right away. I might have misunderstood that. I thought somebody reported that it's not always just a DOI, but that they, in the Bronx, go sometimes directly to the Bronx DA. Am I correct about that?
Yes, so I will clarify that. It sounded like the prosecutor from the Manhattan DA's office wants us to immediately refer cases to the Manhattan DA's office. The protocol is such that we immediately refer cases to DOI. If DOI rejects it and sends it back to us, and then we conduct our own investigation, if during our investigation we then uncover criminal activity, we can refer to DOI and the DA's office. That's where the difference is. We do not do immediate referrals to district attorney's offices. We do immediate referrals to DOI. It is DOI's responsibility to conduct criminal investigations. It is our responsibility to conduct administrative investigations.
All right, so I would just, I don't know the politics of this enough. I understand what you're saying the protocol is, but you were a prosecutor, I was a prosecutor. I know I want those referrals as quickly as possible, so I would suggest that maybe you can all get in a room together and talk about it to see if there's some way to do what Manhattan DA's office is asking, which is a simultaneous referral, because you have limited resources, DOI has limited resources. If Manhattan's saying they haven't had one case referred and they've got the resources to handle what would be their criminal prosecutions, it sounds to be reasonable, so I would just suggest that.
I would be happy to have that conversation with Commissioner Garnett.
Thank you.
Thank you. Chair Cephas had to step away for a few. We're going to continue with DOC, and then we're going to ask health and hospitals to come up and do their presentation. Could you speak to, there was DA Clark mentioned surveillance cameras. Could you speak to the status of cameras on the vehicles and the percentage of facilities that have coverage spots and blind spots and that sort of thing?
Yes, I'm going to defer to the First Deputy Commissioner.
Thank you.
Good morning. We currently have 15 inmate transport buses which have video surveillance on them. 14 are equipped with body-worn cameras, and one contains the Genetec solution similar to what is in our facilities.
Out of how many buses do you have?
I don't have the exact number of total buses that we have, but we have vehicles that are for other purposes than transporting inmates. So we focus our pilot on those inmate transport buses that would either go to court or are used for state transport, so on and so forth.
It would be helpful if we can get, what buses, whether they're used for Manhattan transport, Bronx transport. How long has the camera pilot program been in play on the buses?
So the pilot began in June of 2017. We initially outfitted 5 buses with body-worn cameras. Then it was in May of 2018, it was expanded to a purchase order was issued to outfit the 1 bus with the Genetec solution. And then in December of 2018, we expanded the pilot with the body-worn cameras to include, we have compartments in the front of the buses for special category or vulnerable inmates. And so we expanded the coverage of the buses to not only include the back of the bus, which is the general seating area, but also the special compartments in the front.
And do you know, has there been any complaints of sexual assault or abuse on those buses with cameras?
So, the pilot was both, there was a comparative period and our broader time period, which included the pilot in general. So as I stated, the total pilot period was June of 2017 to March 1st of 2019. So during our comparative period, which was a 6-month period of September to March, there were 810 total allegations reported to the investigation division of either a sexual harassment or sexual abuse nature, and 6 of those happened either on or around the general area of an inmate transport bus. And then if we account for the entire period, which was a 21-month period of the overall pilot period, which encompasses June of 17, again through the end of February of 2019, there were a total of 11 of the 2,235 alleged sexual harassment or sexual abuse incidents that occurred around or on an inmate transport bus.
And it was on those buses with that surveillance capacity?
Well, not all of them, but of the total universe of buses that could have, of incidents that could have been captured by our pilot, 11 of them were during the period of the entire pilot, and 6 of them during the comparative period. It doesn't necessarily mean that they occurred on the buses that had the video.
Got it. Perhaps, offline, we can have a conversation, because part of the pilot, right, is to put cameras on the buses to deter assaults from occurring, but also to be able to use that image to help in the prosecution of anybody who commits that. So perhaps offline we can talk more about.
There was one case that was where video footage, although the video did not capture the actual act on a bus, the footage outside of the bus was used in the investigation. So we'd be happy to share that with you.
Okay, thank you.
Just to follow that for 1 second, is there anybody here that knows how many buses you have?
Total inmate transport buses?
Yeah.
I could get that number for you.
Okay, I've said this before, 15 buses to have cameras. The New York City yellow school buses have cameras. Many buses in the transit system have cameras. This is about the safety of the employees and the detainees. Like, you gotta get these cameras on the buses. It is a place of hazard and danger, and it's in everybody's best interest. If we could figure out how to get it for the kids, we could figure out how to get it on correctional officer buses.
No one is disagreeing with you or the board.
You guys were here a year ago talking about buses and the experiment and the not you, but some of your colleagues. It's.
This is a pilot.
How can the Board of Ed figure out how to do it and you guys can't do it?
No one is saying that we can't.
So we would like perhaps a plan, and Chief, if you want to add.
So currently, the plan is, now that we have the comparative period and we've been able to compare both body-worn cameras, which have to be placed on the bus in a holding bracket, looking at the pros and cons of both technologies, both the Genetec solution and the body-worn cameras, our plan is moving forward to outfit new buses, which we currently have a purchase order out for with the Genetec solution going forward. So that is our plan. Obviously, it doesn't make much sense to install a Genetec solution, which is more costly, although it is a better solution than the body-worn cameras. It doesn't make much sense to install the Genetec solution on a bus which may be at the end of its useful life. And so that's why our plan is to put the Genetec solution on new buses as they come in. It allows for the opportunity to wire the buses appropriately. There will be more cameras installed on the buses. The cameras pick up both video inside of the cabin at different locations inside of the bus as well as outside. So it does provide other advantages.
So I don't want to continue to take up time here, but perhaps we could discuss like what that plan looks like, because I think what Michael is saying, if you have 300 buses and only 15 are wired, or if you have 100 buses coming in, it's going to be 10% of the vehicles. We should talk in detail.
No.
I think we want the same thing.
Absolutely, we do want the same thing, and that's why as I stated earlier, we started out with 5 buses, and then we added buses because we wanted to not only include, we wanted to have sufficient buses to cover all of our boroughs that we go to the court parts, as well as buses that make state runs and so on and so forth. In December of 2018, given what we had learned, we also then began to outfit it the smaller front compartment, which is where we place inmates that are either a special security category or a vulnerable population, which falls under PREA.
Gotcha. Thank you. We have a couple of questions regarding transgender.
I'll start that off. That's just a topic we haven't gotten to yet, so I don't know, Commissioner, who you'd like to answer the questions about housing according to gender. So I just want to shift the topic. I know there's a number of topics to get to today. This one's about housing by gender identification and housing of transgender people. I'd like to know from DOC, I know you've made some progress. You've transferred the transgender housing unit over to Rosie's from a male facility. Can you tell us what policies and practice changes DOC has made in order to house people according to their gender? And then I'd like to know a little bit about, I understand there's 6 transgender males currently being housed at Rosie's, if I understood the commissioner correctly, and I'm wondering why they haven't been transferred to a male facility.
So just to start, just to give a little background of what we've been doing, the Transgender Housing Unit, THU, was transferred or moved from Manhattan Detention Center to our female facility, RMSC. That was in July. And then starting in October, we started housing by gender identity. And so what we did was, if an individual comes in and identifies or has been identified as transgender female, that individual will complete their process at the female facility. So if you remember before, if they did that, they would stay at the facility where they came in at. If they came in a male facility, they would stay at that male facility, and then the assessment would be done at the facility they were currently being housed. Now what we do is we transfer those individuals to the female facility so they can complete their new admission process at the female facility as well as their assessment at the female facility. And once they identify for us whether they want to go to the female facility or go to THU. If they don't want to go to THU, they are assessed to stay at the female facility and housed in general population. If they are not approved after the assessment, we feel due to safety concerns they cannot stay at the female facility, then another facility will be assigned to them to be housed. But if not, then we would place them either in the THU or we would place them in our general population at the female facility.
So just to follow up with my questions, what other policy and practice changes have you all implemented to house according to gender identity, and specifically if you can talk about transgender males?
Okay, so as I mentioned, that is a big difference for us. Like I mentioned, we would normally keep the individual at the facility that they're at if they started out at the male facility and do the assessment there. But now, once they identify as transgender female, they are moved to the female facility to complete the process. And also, our transgender male population, which according to my information, we now have 3 transgender males in our custody. They are currently at the female facility because they opted to stay at the female facility. And like the commissioner said earlier, if an individual is requesting the male facility, we would do a case-by-case assessment of that individual at the time.
Okay, so I think you're saying there's 3 transgender males at Rosie's right now?
Yes.
In which unit?
I'm not sure, they're not in the, oh, I'm sorry.
Well, I mean, is it in general population? Is there a special unit for transgender
Yes.
males in Rosie's?
No.
So
There
are
is
they,
not.
are they in general population?
Our transgender housing unit right now is for transgender females.
Right, so that's why I'm asking about the males.
I'm not sure if they're in a general population or a special housing area, but they're not in the THU.
So if one did elect to be housed according to his gender identity into a male housing and it was determined to be safe and secure for him to be transferred, is there a particular facility right now that you are using for trans men?
No.
Have you had any trans men yet placed into a male facility since you've started housing according to gender identification?
No, we have not. We have not gotten that request.
How many persons does the department now have who are transgender or who have requested transgender housing, and how do you maintain that information? I have a series of questions. That's the first one.
You said, how are they, I'm sorry, I didn't understand the first part of your question.
How many persons does the department understand within its custody who are transgender or who have applied for THU housing? And how do you track that? Is there a system for tracking people who have applied for THU housing and for your categorization process?
So since we've been housing by gender identity, we have received approximately 96 forms. We don't call them applications anymore because they include the THU as well as the female facility in general. So we've had 96 individuals make the request. And we keep this information. We're working on developing a database, but right now we have a unit within the PREA unit that is geared to making sure to track our individuals who identify as transgender and or intersex.
We need the numbers.
So where, excuse me?
We need
Yeah, how many trans women are there right now? And where are they housed? Are they housed in THU, protective custody, or general population?
So right now, we have a population of 16 in THU. We have 6 in our general population. We have 1 in our new admission, and of course, this is not as of right now, this is as of yesterday's statistics. And like I said before, we have 3 transgender individuals at Rosie's, and we have 24 who are not housed in the female facility.
4 who are not housed in the
24.
24 who are not
Yes.
housed there. And do you know how many of them are in protective custody?
I'm not sure. I would have to get that number to you.
How about how many of them are in intake? We've heard concerns that transgender persons are maintained for extended periods of time in intake facilities. Is that a practice that you're aware of?
No, not at all. They go to intake and, I'm sorry, I don't understand. They're housed in intake?
Yes.
No.
So your numbers reflect more transgender women in male facilities than at Rosie's, is that right?
That's correct.
And no
Actually,
transgender...
I'm sorry. So we have 24 who are not in the female facility, and we have 26 who are at the female facility.
And are the criteria for accepting someone in THU in writing?
We are in the process of developing a directive geared to our LGBTI and GNC population. However, staff is aware of what we're doing, that we're housing by gender identity. Some information went out to them, but we are in the process right now of working on an actual directive.
So if someone says, I'm transgender, do you say, okay, or do you question it?
No, we do not. If a person is identified, whether they say they're transgender to the intake staff knows that they need a form to be filled out where they're asked whether they want to go to a female facility. If they're not already at the female facility, if they're at the male facility, then they're asked if they want to go to the female facility. On the form, it asks whether you want to stay at the male facility, whether you want to go to the female facility, be housed in general population, or be housed in the THU.
And again, just on protective custody, we've heard concerns about the use of protective custody for transgender persons. Is that a practice of the department?
We would place somebody in protective custody. They are interviewed for protective custody. If we feel that there's a safety concern, if they're requesting it, then we would place them in protective custody. But we don't involuntarily place anybody in protective custody.
Do you have the staffing in protective custody? Is that the same as in general population, or do you have higher levels of staff to protect people in protective custody status?
So the staffing in protective custody depends on the need at the facility. So it just depends
So
on
it
how
could
many
be the
individuals.
same level of staffing as
It depends on the need
for
of the
protective
housing
custody.
area.
Thank you. I just wanted to sort of follow up on Dr. Cohn's questioning and understand under what circumstances, if any, would an individual who was housed in the transgender housing unit be transferred to a different facility?
So another assessment would have to be done. It depends. I can't say specifically, oh, if this happened or if that happened, but another assessment would have to be done of the individual if the individual is not requesting to be removed from THU. They may have to be removed from THU due to safety concerns, whatever that safety concern is, and then we would probably, depending on what the concern is, place them in our general population at the female facility. So it just depends, and we have to assess it on a case-by-case basis.
And if they were moved, they would be transferred to the general population in the female facility?
If safety allowed, yes. Like I said, it would have to be a case-by-case assessment. We don't just remove somebody from THU and then put them in a totally different facility. We make an assessment of what's going on, and then we make the movement.
And whom is responsible for making that assessment?
We have a unit in the PREA unit that tracks and keeps information on our transgender population, because as you know, the board receives our biweekly report. And so in order to give the board that information, we have to make sure that we have individuals that are keeping track of everybody in our custody who has identified as transgender and or intersex. And so that information is gained by them. And in conjunction with, if we need to talk to medical, if we need to talk to the facility for other security concerns. So it just depends on why the person has to be assessed or reassessed.
How many of the transgender women who are in men's facilities were in Rosie's general population before going to a men's facility?
So currently, 3 individuals were removed from the female facility. Either they requested to be removed, or due to some security concerns, they had to be removed. Out of the population, yes, 3. I'm sorry, 3.
3 requested to be moved to a men's facility.
They requested to be either requested, or due to security concerns, they had to be removed.
When I was in the transgender housing unit recently, and I think Jackie was with me, The understanding there was that women felt if they were in the transgender housing unit, that was the only option, that if they were going to be moved out of the transgender housing unit, they were going to be moved to a men's facility.
I'm not really sure who you spoke to.
Well, how would they have different information? How is it communicated to them where they could possibly be housed when? So that the whole idea of housing by gender identity, how is that communicated to someone in writing?
Oh, in writing. Like I said, we are in developing the directive as well as additional information to hand out to people who come into our custody or who are already in custody. So in writing, we might not have it. However, our PREA unit is in that facility and in those housing areas on a regular basis. We also have our PCM and our PREA ambassadors who frequent those housing areas, those 3 housing areas on a regular basis, and they communicate to them that if they are removed from the THU or want to be removed from the THU, they have another option other than going to the male facility.
At Rosie's, they have another option.
Yes.
Since there's
I'm
so
sorry,
many-
can I just make a correction? Thank you. We do have the form, right? So if somebody communicates that they're having, it's a transgender intersex housing unit form, I believe we shared it with the board. If we have not, we'll make sure to share it with the board. And they indicate on there if they're going to be removed or they're requesting to be removed or we think there's a security concern, we would have them fill out another form to indicate where they would like to go.
Are those forms located in the transgender housing unit?
No, they, the staff in those units will communicate that to someone in the PREA unit. They would start first with the PCM who's located in the facility and/or the 2 PREA ambassadors who are located in the facility. If not, then somebody from the PREA unit would speak to them and make sure a form is filled out. Another form.
Since there's the majority of transgender women are not housed in Rosie's, but it's a policy that you will house people according to their gender. Does
I'm
the
not
department
sure.
have any?
I'm not sure why you're saying majority.
50%?
Yeah.
Oh, 50%.
Sounded like
Okay,
50%.
50% or not.
Mm-hmm.
Well, that doesn't seem like an idea.
And out of that
Yeah.
15 did not want to go to the female facility. So I just want the board to keep that in mind as well.
Do you think there's a need for an additional THU unit in Rosie's particularly? Seems like, I mean, from what we've been informed, there are issues of conflict between individuals or classification issues in terms of the department, which make you say someone is not eligible to be assigned or remain in a THU. Wouldn't it be appropriate to create additional capacity? And also, the board did recommend in its THU report in the past that you electronically track. When do you think that system will be available? Those are 2 separate questions.
So let me do the second one first because I remember that one. We do have the information in our IIS system. Anybody who indicates it on the screening tool, that information is captured from the screening tool into IIS and therefore into the hub. So we do have that information and not everybody has access to that information due to confidentiality reasons. I'm sorry, what was the first?
Yeah, I mean, it's our understanding that, so I guess we'll have to clarify with you what that report is. We thought there's that we had requested a specific tracking system, which is not just that you can look it up in IIS. But I'll have to get back to you, or we'll get back to you on that.
Okay.
It was actually tracing THU applications and decisions. That was have you created a system to track THU applications and decisions?
If you're asking, do we have an electronic
Yes.
database? We don't have an electronic database yet. We're in the process of working on that.
And when do you think that will be available?
I think we testified about our CMS before, so I'm not really sure. We'll have to get back to you.
That was about PREA.
Yeah,
That was about PREA report. It's not
on-
about THU applications.
Well, the case management system
Yes.
is something that we're working on, and we intend to include this tracking in the case management system.
So THU applications will be part of the case management system,
Yes.
the PREA case management system.
If we can develop that, we're looking into it. We are looking into electronically, other than the IIS and other than the hub.
And the other question was about the need for an additional THU unit for persons who, because of the number of people, number of transgender.
So right
persons in
now,
the
we have 16 individuals in the THU for a housing area that can house, it probably has maybe 45, 50 beds. We probably would never go that high for obvious reasons, but we only have 16 in the THU right now. And so when you're talking about real estate and also additional staff who have to house a housing unit, you know, it becomes a difficult conversation. But we have 16 in the THU, and we have enough space that we can add if anybody would like to go to THU or request to go to THU.
Thank you.
You're welcome.
Just wanted to ask a couple of questions in regards to your screening information.
Yes.
Can you tell us how many people in the department's custody at this time, about how many have been assessed to be at risk of sexual victimization, as well as those who are at risk of being sexually abusive? And then once you obtain that information, what systems and strategies do you have to use that information to try to keep them and those who are more likely to be abusive from abusing anyone else?
Okay. Right now, and again, these are stats from yesterday, we have 177 individuals who are designated as potential sexual abusers. We have 490 who are designated potential sexual victims, and 53 who are both designated an SA and an SV. And we have 6,720 who have a non-designation. And any individual who is an SA, we have SV houses located in every facility except for, I'm sorry, potential sexual victim houses. I'm calling it SV, sorry. We have those houses located in every facility except for the West and NYC. And so anybody or designated as an SA would not go into a house or a housing area that's designated for our potential sexual victims.
Right, but a sexual abuser can abuse people who are not necessarily determined to be at risk of being sexual victims. So how do you protect the other inmates from those who have what's been determined to have be a propensity for sexual abuse? What do you do with that information?
If somebody is designated a potential sexual abuser.
Yes. Other than not put them with those that are deemed likely to be sexually victimized or at risk of.
Sure. So our staff in the facility, either our PREA compliance managers or our PREA ambassadors, they have this information and they know to go to certain housing areas to monitor the activity in those housing areas. And also with the Genetech solution that we're going to expand to some of the individuals in the PREA unit, we will ask that they also monitor certain housing areas. But staff is well aware. Most of the staff has received the PREA training, and they know what to look out for. We don't tell staff everyone who is potential sexual abuser for, of course, obvious reasons, but the PREA unit staff is aware.
So again, anytime that those inmates are identified, they're housed in the cells closest to where the officer's station is for extreme monitoring.
Thank you.
I would also add that it's used for help to assist with program placement and different housing placement, and as the chief said, cell placement.
No other questions, and Chair Cephas is back at the table.
Anything else from the board on? Thank you.
Thank you.
So next we'll hear from Health and Hospitals Correctional Health.
Good morning.
Good morning. Ross McDonald, Chief Medical Officer for CHS. So we had not prepared extensive comments, but I will just mention how important this work is to us. It's a core function of CHS and critical to our mission to engage in this work, to be for our patients that safe space that D.A. Clark mentioned. And we have built, in partnership with the department, very clear systems of reporting and cross-reporting. Our core responsibility is evaluating patients immediately after an allegation, and that involves an evaluation on the medical side as well as on the mental health side, and that is offered to 100% of allegations that are made in the system today. We also have a key role of evaluating the need for forensic examination. So as healthcare providers, we don't do forensic examinations on Rikers Island, but we partner with our colleagues in health and hospitals at both Elmhurst Hospital and Bellevue Hospital, where there are expert teams who are trained specifically to perform those evaluations. Our role is one of triage in those cases, and we have board-certified emergency physicians who work for CHS who help our primary doctors and physician assistants and nurse practitioners decide when a referral to the emergency department is appropriate for that evaluation. A few things within the last year or so. In 2018, as the board knows, we implemented the Sexual Abuse Advocacy Program to provide additional supportive services for those who experience an episode of sexual abuse while incarcerated. And that program has been able to connect with 82% of those patients who have made allegations since its inception. So we're very pleased to have been able to offer that additional service. And as well, in 2018, we implemented our own training for our staff that meets the criteria for PREA training, but is specifically tailored to the role of clinical staff. And we're very pleased to have additional clarity about issues specific to our staff, including our workflows, and particular sensitivity towards transgender patients who we know are at particular risk. So with that, I'd be happy to answer any questions.
Thank you so much. I just have a couple of questions about the forensic medical examination. So since our standards went into effect in January 2017, how many people have actually been referred for forensic medical examinations by SAFEs or SANES? And of those referred, how many actually obtained the forensic medical examination?
Sure. So it was, hold on, let me just find the right number. 66 cases, and that's inclusive of calendar year 17 and 18, were referred. We, as CHS, again, as the care providers, will make that referral, but we hand off the remainder of that process to our colleagues at health and hospitals, and it is a forensic process, so there is a little separation from clinical care. So we don't have numbers on the outcomes of those. Those would be transferred through chain of custody to the appropriate authorities once they're completed. We will collaborate, though, on clinical aspects of care, as often post-exposure prophylaxis is indicated in these cases. So we may initiate that before we refer, or pick it up from the emergency room evaluation.
And can you just talk a little bit about what the factors are that cause a referral to be made for the forensic medical?
Sure. So our ED physicians who triage all referrals to the hospital by virtue of being board certified in emergency medicine are trained in the criteria which warrant forensic evaluation. And those are factors such as, the time from the allegation, the nature of the allegation, exactly what is alleged. And we try to be broad and err on the side of referral.
Okay. And when there is a referral for a forensic medical examination, are you aware of whether the necessary protocol includes taking the clothing or bedding of the alleged victim in those cases?
So part of our training for our staff is to acknowledge that our patients should be advised to preserve their clothing when they're in front of us. The initial stages of that would be in the housing area and would be correctional staff.
And is there a coordination with correctional staff in terms of these allegations, if they're to be made to the healthcare provider and not to DOC or not called in on a hotline?
Yes, absolutely. So the key function of our staff cross-reporting, and that goes through our central operations desk, which is active 24/7 and tracks each case to its completion, being offered all the required services.
Okay, thank you.
Thank you for speaking with us. Can you talk about your collaboration with the Department of Correction when there's an allegation that involves one of Health and Hospital staff? What protocol is in place to protect the accuser, and how do you sort of separate your staff? Yeah.
So we take all allegations very seriously. There have been no substantiated sexual abuse cases against health and hospital staff since our transition to health and hospitals. But as you heard DA Clark mention, we know that there is a power dynamic at play and a possibility. So we take any allegation extremely seriously. The immediate responses related to patient safety, so a collaboration and a decision ultimately by our clinical service in collaboration with our Senior Director of Risk Management about what the immediate response should be. That may be a prohibition of contact between the clinician and that individual patient, up to removal from care immediately. So that would be the spectrum of interventions that we would take in the moment.
So, quick question. In view, we heard earlier, in view of the large number of unsubstantiated cases, does that fact itself give rise to any need for additional mental health assistance, mental health intervention? Do you get a lot of people, inmates seeking mental health assistance because they've had a claim that's been unsubstantiated and they think they have not been fairly, the case has not been fairly or accurately or appropriately investigated? Do you see that at all?
I don't think we see that as a source of seeking out mental health care or particular distress that's come to my attention. I think the department has made great strides, and our patients seem to feel that.
Oh, good. Yeah. Okay. Dr. Cohen.
I think DA Clark raised an issue regarding lack of forensic evaluation. Could you respond to her concern or her statement?
Yeah, so I think I would like some more specificity about the case or cases that she's referring to. I know in some cases there can be complexity around the way a case is initially reported, and it may initially be reported to clinical staff as a consensual act, which would not typically take it down a forensic evaluation path. And that's important to preserve because of our confidentiality relationship with our patients. So there have been some cases where the indication for a forensic examination was unclear or shifted over time, depending on the clinical history that was given to us. But I'm not sure what the specific concern that she was raising. I will mention that there was a time when our emergency physicians on Rikers Island performed the forensic examinations, and it was a collaboration with the department as well as the Moss Group to change that practice to remain true to our mission of providing care rather than performing forensic evaluation, as well as to make sure that that evaluation, when it does happen, is in a location outside the jail with staff who are expert in that and do it as their primary job.
Yeah, just following up on that, two things. I understand why you do that, and it makes sense to me. On the other hand, I would imagine for some people waiting to get transported to Elmhurst or Bellevue in that situation is going to be add to the trauma of their situation. And or do people refuse who you think should get forensic evaluations for that reason?
I don't have a lot of cases that are coming to mind where we're sort of concerned based on the nature of the allegation that a forensic examination really would be valuable in the person's refusing.
And then where would the thank you. Where would the result come? Say there was sperm was found in a vaginal specimen, for example. Where would that go?
So it would not come to CHS. It goes through the chain of custody process that's in place at the hospital.
To whom? Who would it go to?
I'm not sure exactly.
It would go to, you think, I was wondering whether the DA's concern reflected information also, just not getting to her or to DOI in a timely manner. Do you
It's possible.
Does the department know that?
Hello. The question was about where do the results of the forensics exam go. We do get results from the Office of the Chief Medical Examiner. I can't speak to the DA's office. I think they may send it to the DA's office as well, but I don't want to speak for them.
And you don't know how long it takes for you to get those results?
It varies.
Can you give me some range?
It does take some time.
Like weeks, months?
Months.
Okay. And then, thank you very much.
You're welcome.
And then the process that you have for, that you either contract with or provide of support for persons post-sexual abuse, there was a question earlier about having an advocate or someone present at investigations. Does that person, can they provide that kind of support during investigations by ID or DOI staff? Or DA staff?
Our SAA program, as it's designed, does not have that capacity. I do believe that there are separate advocacy services available in the context of the hospital evaluation.
Yes, yeah. But not in the jail itself.
Not in the jail itself. The program seeks to follow up within 24 to 48 hours.
I assume I know the answer, but I just want to make sure. So when you say when the allegations or when a alleged victim comes to your staff and says that it's consensual, you don't then send that for forensic. I assume that's only when you're talking about an incarcerated person with an incarcerated person.
Absolutely.
Not with the staff. Because with
Absolutely.
the staff, they can't consent.
Absolutely.
So a forensic would be done in those cases, if it's appropriate.
Yes, and
Based on the circumstances.
thank you for making that critical
Okay.
clarification. That's a key element of our training for our staff.
Yes, thank you.
And could you talk about your vetting process when it comes to staff and experiences as a sexual abuser or abusers?
Yeah. So,
Good morning.
Good morning.
Still good morning. Jonathan Wangel, Senior Director for Correctional Health. So, every candidate for employment, whether it's health and hospital staff, affiliate staff, vendor staff, contractors, volunteers, interns, they all go through the same HR, full background clearance, full vetting, state registry checks. Everybody is checked, to the full extent possible. And anybody who comes back with a hit, of course, is excluded.
And I'm assuming you do training before they start in terms of reporting to be able to identify it in the protocols.
Correct. PREA training is part of all new hire orientation. It happens twice a month. Every staff member completes it before starting.
And that's a question for DOC too. I don't think we got a chance to ask about in the academy, what is the level of training that candidates get with respect to PREA?
So thank you for letting us explain this. So we do the 4-hour, really in the academy, the 5-hour training with the recruits. And so they already come into a facility having the PREA training.
Okay. Thank you. Thank you.
Any other questions? Thanks very much. So now we'll hear from the Westchester Department of Correction. Yeah.
Good morning, Mom. My name is Leandro Diaz, and I'm the Deputy Commissioner of Operations for the Westchester County Department of Correction. And given the importance of PREA, I also serve as the department's PREA coordinator. Thank you for allowing us the opportunity to speak briefly on these steps we took to operationalize and achieve PREA compliance. We have had policies in place prior to 2003 that address sexual assault and that were in line with the 2003 Prison Rape Elimination Act. In 2012, the Department of Justice promulgated a set of regulations, also known as the DOJ PREA standards. At this time, the Westchester County DOC began the process to become PREA compliant to ensure that we operated under the best practices to prevent, detect, and respond to sexual abuse and sexual assault of our custodial clients. How did we do this? First, we made a decision that given the importance of the work that this process required, we needed to be led by an executive or senior uniform member of the department in the rank of warden or higher, so that the person could be fully empowered to make operational decisions on implementation, and more importantly, ensure accountability. Ultimately, the decision was made that this work would be led by the Deputy Commissioner of Operations. In preparation for the audit and to ensure we would have comprehensive policies and practices, we attended numerous trainings offered by the National PREA Resource Center and used various reference guides issued by the National Center for Transgender Equality, the ACLU, the National Institute of Corrections, and Just Detention International, to name a few. We also participated in a week-long DOJ auditor training so the department would have staff that knew how to internally ensure that the department was performing to the intent of the standards. This engagement with outside parties also ensured that LGBTI, the most at-risk group as it relates to PREA, were included in how we operationalized our process. While the PREA standards included several protections for LGBTI, our department felt that we should go beyond what was required within the jail standards. By using guides, much like the ACLU advocacy guide, we were able to establish meaningful changes like ensuring that we use preferred pronouns, preferred name, housing preference, and strip search gender preference. We also created a standalone LGBTI policy that covered guidelines for safe confinement, employee conduct, communication, searches, and other areas. Also recognizing that transgender and intersex inmates face many challenges while in custody, we took the additional step of having the client meet with the PREA coordinator upon admission, thereby ensuring that they were aware of PREA, the methods of reporting abuse, provided point of contact, and so we can assess how they were adjusting to the environment. The department found that most often clients' fears were reduced as a result of this encounter with high-level staff. This engagement, like all PREA interviews, is conducted in a private, confidential setting outside of the jail housing units. Lastly, the department's mental health provider was tasked with having monthly contact with identified transgender and intersex inmates, whether or not they had a mental illness, in order to conduct follow-up safety and welfare inquiries. It is vital that our custodial clients and our workforce have confidence in our PREA process, so through academy and in-service training, along with the supervisory accountability, we have an institutional culture that feels they can make a complaint confidentially if need be, and all allegations are fully investigated. Part of this process is having a documented, coordinated response plan, which includes the Westchester County Department of Public Safety, the Westchester County District Attorney's Office, our Department of Corrections Special Investigations Unit, and community support agencies. At a minimum, every allegation is reviewed by the DOC's SIU, with consultation as needed with the on-site detective from Westchester County Department of Public Safety. On a monthly basis, the department's Sexual Assault Incident Review Board, consisting of the department's medical director, the director of mental health, director of nursing, and Health Services Administrator, PREA Coordinator, and SIU Commander review all investigative findings to make sure all allegations were investigated according to policy, identified if additional issues need to be addressed, example, staff training or camera sightlines, and also to determine whether race, gender, or gang were driving factors in the allegations. All of this level of accountability ensures that victims and reporters can feel confident there will be no reprisals for their allegations, but more importantly, we make every assurance to protect victims and reporters. All interviews are conducted in private, confidential settings. We do not conduct ourselves in a way that would further victimize the victim. We approach the interview as an information gathering process and do not use interrogation tactics when interviewing victims and/or reporters. All victims are provided with immediate medical and mental health services, and when deemed appropriate by our medical director, are taken to our local hospital for follow-up with the forensic acute care team. Final outcome of this is in 2017, the department was issued a final PREA report, which noted that we were 100% compliant with the 43 PREA standards and exceeded 13 of the 43 standards. Thank you.
So good morning. My name is Louis Molina. I serve as the first Deputy Commissioner for Westchester County Department of Corrections. My colleague briefly walked you through how we as a department successfully implemented and ensured that we had a PREA process that achieved DOJ PREA jail standards and created a robust atmosphere that prevents, detects, and responds to sexual abuse and sexual assault of our vulnerable population. In closing, I just wanted to take 2 minutes to touch on why we are successful to be PREA certified. We're able to achieve this because we have created an evidence-based ecosystem that ensures that our most vital asset, our workforce, has support via training. There is regular direct supervision from first-line supervisors all the way up the chain of command, coupled with our strategic nonprofit vendor partnerships that work daily with our staffs so that our staff understand the impact of adverse childhood experiences and secondary trauma, and the importance of our custodial clients need to be encouraged to stay connected with their loved ones. And so the way we do this to foster a positive visits between their family and friends, we do not conduct strip searches before visits of persons in our custody or their visitors. This ensures that we have a secure and safe rehabilitative environment that maintains a person's dignity. PREA compliance is one of our many accomplishments. We are also certified by the American Correctional Association and the National Commission on Correctional Health Care that also have PREA components to them, which means that we voluntarily operate at the highest standards and best practices in corrections. I shared this with the board because while the topic today is PREA, PREA compliance is but one of many vital standards along with our other programmatic best practices that allow the staff, our custodial clients and partners to work and reside in a safe and secure rehabilitative environment. On behalf of our Commissioner, Joseph Spano, I want to thank you for your time and for allowing us an opportunity to add our voice to this important conversation.
Thank you. I just want to thank you, first, and then if you could, I guess, sort of related questions. I mean, the way you approach visitors is very interesting. I mean, certainly we've received many concerns from visitors, about that, and also were there some incidents that led to the department's commitment to this project? You said you've gone back for 15 years on it, but in the past 5 years, is there a reason why you've taken such an interest and come down to see us? And thirdly, does it work in terms of prevention of sexual abuse in your experience?
Sure. So my colleague has been with the department for 30 years, and I've been there for about a little over a year now. But what I think in our ideologically, as we took over in the new administration in Westchester County, we felt that the commissioner, the leadership of the jail had to also be the advocates for the vulnerable population that's in the jail. That's why we take this very serious, and we make sure that we educate our workforce and work very closely with our strategic partners and making sure that we can deliver information that the population needs in order to seek assistance if they feel they need it. Any particular thing that might have triggered this during your time?
No, I mean, one of the main factors also is, while we wanted to have best practices, we also house federal inmates. And part of PREA is that if you contract with a facility that has, federal inmates, you need to be PREA compliant. So that was one of the factors, but There was no spike in assaults or claims or allegations. We just wanted to have, like NCCHC and ACA since 2010, we wanted to make sure we follow the best standards under PREA as well.
Can you talk about, you said y'all have monthly meetings where y'all review every allegation and whether or not the investigation was thorough. Does that include the Westchester County prosecutor?
It doesn't. We've met with the DA's office, initial stages and throughout investigation. We feel it's warranted for it to go to the DA's office, but it includes the department structure. And we just review based on PREA standards to make sure that everything was covered. You know, if there was an investigation, was there any sightline issues with cameras? We add additional cameras. We do a lot to deal with the prevention part of it, right? With assessment tools when they come in through the jail, upon intake. We move away from dorm housing and single cell occupancy that we go to. We have over 1,200 cameras. And whenever we do an investigation, we look at, even if it's a use of force investigation, was there an angle that wasn't captured that may, you know, probably allow this to occur? And then we add that camera. So we do a lot to manage the preventative part of it.
What's the population of your jail?
We've been up at, we can hold up to 1,800 inmates. We've been at 1,500 about 5 years ago. And now, like every other county, we're seeing a downslide, so we're at 1,000. And we've raised the age, we're losing minors, but we have about five or six male and female minors.
No. And what about your protocol for collecting forensic evidence?
So we were one of the first jails, actually. We offered the training, through the National PREA Resource Center, we did sexual assault training in confinement setting, which was specific training that needed to be done. We ran it through the Sheriff's Association for the state of New York, and we actually hosted that training at Westchester County. But when we have a serious allegation, we work with, we have detectives from county police assigned to the jail. We pay their salary. They're assigned to the jail to help us in those cases. They use their crime scene unit, they use the sexual abuse investigators, and in concert with our own investigators. So serious allegations, where it requires a crime scene or forensic evidence gathering, we call in county police right away.
Thank you.
Thank you very much.
Thank you.
Thank you very much.
Thank you.
So now we are going to, I think that's completes a part of the hearing for the institutional people, institutions that are testifying. We now read to the speakers list from the public. And the first speaker is Scott Moffitt. I understand there's 5 minutes per speaker?
I have
6 minutes per speaker.
Oh, thank God.
All right.
Good morning. Good afternoon now, I think. My name is Scott Moffitt. I'm a police officer for the Allegheny County Police in Pittsburgh, Pennsylvania. I've been a police officer for 17 years. For 8 of those 17 years, I was a detective assigned to the General Investigations Unit, which included investigations of all sexual assault crimes. I drove 6 hours to be here today on behalf of my brother, Jonas Caballero. Jonas is many things. He is a brother, a son, he's a Fulbright scholar. He obtained a Master's of Philosophy in Middle Eastern Studies from the University of Cambridge in the UK. He has worked as a human rights activist in Israel and Palestine, and he was once a man on his deathbed. He became extremely sick 4 years ago and slipped into a coma. I received messages from around the globe in several different languages, all people saying my brother changed their life in one way or another, and that they were praying for his. Currently, he is a prisoner at Green Correctional Facility, serving a 3-year sentence for a first-time nonviolent felony drug offense. On March 6, 2018, Jonas was sexually assaulted by a correctional officer when he was a detainee at the Brooklyn Detention Complex. Jonas reported the assault to a captain, and the captain called him a liar. Not knowing the proper procedure for reporting sexual assault in prison, he told a female officer who laughed, pointed to his crotch, and said that the officer probably thought that his genitals was contraband. He reported the assault to a second female officer. She told him that he shouldn't have minded the assault since he's gay and, quote, You people do that kind of stuff all the time. He then contacted 311 and again reported the incident. An investigative team visited him that very day. They informed him that his allegations would be investigated and that he would receive word in a timely manner of the results. He did not hear back. Jonas began filing grievances. He still did not hear back. He had no choice but to file a prisoner's rights lawsuit in federal court, and still he has not heard back. It should be noted that on the same day as my brother's incident, another incident occurred under very similar circumstances on another inmate from that same officer. My brother was surprised and shocked to see that that officer on his unit for several days, even after he reported the incident. He decided to rather stay in his cell than to participate in optional activities such as visiting the medical clinic or go to the barber shop to avoid further retaliation and or contact. It is now 413 days since the incident, since the assault. According to the PREA and Board of Correction guidelines, the case should have been closed at least 323 days ago. Although I find this unjust and contrary to New York City human rights laws and congressional legislation, it is not entirely surprising after examining the outcome of the Board of Corrections audit of the Department of Corrections handling the PREA investigations. PREA makes it clear that sexual assault in prison is a crime, whether committed by correctional staff or other inmates. It also ensures that prisoners who are victims of sexual assault will have a safe and fair mechanism to bring forth allegations of their sexual assault in their quest to heal and find resolve. My brother has told me he feels sad, frustrated, angry, forgotten, marginalized, and worthless. And this from a man who has a voice and uses it. He feels as a prisoner that suffering through something like this just comes with the territory, that it should just be accepted and everyone move on like it didn't happen. Sexual assault is not supposed to be part of his punishment. Not for him and not for any prisoners, including the ones who are afraid to speak up, who give up after filing the first report, who give up after hearing about Jonas's story, because if he can't get a single response, what chance do they have? Luckily, my brother Jonas has found allies through the Crime Victims Treatment Center, Councilman Daniel Drum's office, journalists from the Gothamist and from the New York Daily News, and through his family. Throughout my law enforcement career, I have seen firsthand the traumatic effects of sexual assault on victims and how they can last for years. One thing that can bring some type of closure in many cases, however, is the timely investigation of these criminal acts and prosecuting those individuals involved in committing them. Criminal acts that occur inside any type of detention or prison facility should be treated the same as those that occur outside of them. It is abundantly clear that the current system is broken, providing no avenue to heal and no measures to resolve. Sexual assault in prison is a crime and recognized as torture under international law. In an era where the #MeToo movement is helping to embolden and empower victims of sexual assault, and at a time where even the New York City Council and the Watchdog Agency Board of Corrections recognizes that the system has flatlined, it is extremely discouraging to stand here today and say that my brother still has not received an update about the investigation into his sexual assault. My brother spent years of his life being a voice for the voiceless, fighting for basic human rights for those who couldn't fight for themselves. Even today, from his jail cell, he knows I'm speaking out on his behalf, and he hopes my words just don't help his case, but the countless other victims who are being ignored by the system and those who are afraid to speak up. Thank you for your time.
Excuse me, I just wanted to say something before you leave. I want to thank you so much for coming, driving 6 hours to be here with us to tell us about your brother's story. We will make sure you give staff your brother's name. We know he's in Greene County, and you're saying that this occurred in Brooklyn? Is that where you said it
Brooklyn
occurred?
Detention, yes, ma'am.
Okay, so
Yes,
in
sir.
2018, you said 413 days ago.
Correct.
We can look into this.
I appreciate that.
And just make sure that you leave your name and your phone number so that we can follow up with you
I'm gonna stick
and your
around.
brother. Thank you.
Thank you.
We're going to call up Ariel Fox and Jessa DeGrody.
First, we want to start by saying thank you very much for having us here today. Thank you for having this forum. Unfortunately, our client's story is very similar to Jonas's story. and we think that his story touches on a number of issues that have come up today. The first of which is cooperating with the Bronx District Attorney. Our client is the person who was mentioned in legal aid's circulation before this meeting. Our client cooperated with the Bronx DA. He met with the Bronx DA in October 2016. Since October 2016, the Bronx DA has not closed the investigation, has not made a charging decision, and until yesterday had not asked to speak with our client for a second time. That's been the status of the criminal investigation. One thing that we think brings to light why people may not be cooperating is while these criminal investigations are happening, the city of New York is asking federal judges to stay civil cases, is telling these plaintiffs they cannot proceed with civil cases, they cannot proceed with ripe evidence while it exists until the criminal investigations close. After our client spoke with the Bronx DA in October 2016, we agreed to stay our client's civil case in order to permit that criminal investigation to go forward. It was only when nothing happened for over 16 months that we finally said to the judge, this is enough. The evidence is getting old. We have to go forward. The investigation has not gone anywhere. In our client's case, we believe that the correctional officer, based on the DOI investigation, also harassed at least 4 other people. That was all referred to the Bronx DA, and as we said, as far as we know, no charging decision has gone forward. The other thing we think this weighs on is your question about people being held in intake. After our client was sexually assaulted and made a complaint, he was held in the intake unit for a prolonged period of time where he was physically assaulted by officers who retaliated against him for reporting the sexual abuse and told him, next time, get some DNA. We think the intake holding is happening and is a problem. We also think that there are issues with the unannounced rounds. To give some context, our client is a gay man who was particularly vulnerable when he arrived at Rikers and therefore was held in the AMKC in Quad 4 Upper. At the time when he arrived, there were no cameras, and there was a guard who immediately took a liking to him, began buying him clothes, food, being extra kind to him, as long as he could also come by our client's cell, block the cell door with the guard's 300+ pound body, and then masturbate our client. Unannounced rounds did not help. The guard was able to block the entire cell door with his body, and when rounds came by, could simply back away or hide what had been happening. We think that there are serious concerns about what's happening with these rounds, whether they're even happening, and think that should be looked into further. We also think there's an issue with staffing and protective custody, which you touched on. Mr. Cohen, you'd asked a question about that earlier. Who's being staffed in protective custody? As we said, our client is a gay man who is supposed to be staffed in AMKC Quad 4 Upper because he's vulnerable, and that's where he was sexually abused. We also think it's come to light in the course of the investigation that there were other staff members in AMKC who were also sexually abusing inmates. We think this is a serious problem, and when our client made a complaint, the captain told him to withdraw it, and he did. We think based on what we've heard from Jonas and other clients, this is a common issue, that they're told to withdraw the complaint, but fortunately, our client's complaint nonetheless led to a DOI investigation.
So as we mentioned, that investigation actually resulted from a very detailed and compelling closing memorandum, which was dated in October 2016. And in that memorandum, the DOI substantiated our client's claims and found that the officer engaged in unlawful sexual conduct with our client and at least 3 other inmates. And this was the result of a DOI investigation that involved interviews of 22 incarcerated witnesses. The DOI immediately referred this matter to the Bronx District Attorney's Office, and as we noted, there is no charging decision there as of last week when we inquired. And most notably, I want to address the zero tolerance policy that Ms. Townsend referenced. No administrative action, despite the fact that the closing memorandum called for it, has been taken against this officer. As of at least 3 weeks ago, he remains on modified duty at a full salary since January 2016. As a result of the abuse, Our client has suffered significant PTSD and depression, and at no point was he treated appropriately. He was repeatedly placed in isolated confinement, given medication, but denied psychotherapy or counseling, and was told by mental health staff that they could not provide him with more appropriate treatment because, quote, jail was no place for treatment of PTSD. So we want to note that even when these types of investigations go forward, and even when referred to the appropriate criminal authorities for prosecutions, there's a breakdown in the system. So if we are seeing a very limited number of substantiated complaints, the hope is that we're successful in taking action in response to them. And our clients and co-counsel from Legal Aid will talk a little bit more about the pervasiveness of these trends, but we note that for clients like ours, they're lucky because they have pro bono representation and can get some form of civil justice. But this doesn't speak to the type of change that we need systematically and the type of change that needs to occur for people who don't have this type of representation. So we thank you for your time, and we thank our colleagues Morton Bass and Hannah Bellitz, who are also attorneys on our client's case. Thank you.
Thank you.
I'm sorry, I'm wondering if we could just ask DOC, not about this particular case, I'm not, we can do that offline, but this would tend to suggest that disciplinary action is sort of stayed or held in abeyance while the criminal matter is decided, which of course would seem counterproductive to reducing sexual violence in the jails, even if this alleged officer with the alleged incident. But if DOI, in fact, substantiated it back in October of 2016, I don't understand why that could not be a basis to move forward with disciplinary action and not stay it pending criminal investigations. If what they're alleging is true, and I assume it is for these purposes, that's a very, very long time to hold everything, what appears to be everything in abeyance.
So a few comments to that. We are mandated to stand down during a criminal prosecution. That's number one. Number two, we take immediate action in order to separate and modify any individual who is accused of such an act so that we can keep other individuals, including the alleged victim, safe. So that is what we can do in the immediate time period while we await criminal investigation and prosecution. There is no way for us to force disciplinary action onto a member of service when they are being prosecuted criminally, because their defense attorney, any defense attorney who's worth any weight, is not going to recommend that their client either A, sign a negotiated plea agreement with us to resign, because that's an admission of guilt that can be used against them in a criminal case, or B, not sign a negotiated plea agreement and instead take the case to trial at oath, at which point they're going to have to testify or they're going to have to present their defense, which would really make their criminal defense case suffer. So we are unable to move forward in our administrative prosecution while criminal prosecutions are open. What
Do you have any sort of arrangement with the district attorney's office? Again, the DA is not here to respond to this, but this is a very long time, and we know the statute of limitations is running, right? So when you say criminal prosecution, if there's not a charging decision, there is not a criminal prosecution right now. There's a referral and there's a criminal investigation, but if what the lawyers are saying is true, there's been no charging, so therefore it's not a prosecution yet. It's just in the district attorney's office.
And if they admit guilt in a negotiated plea agreement, I think it would make it pretty clear that there will be a criminal prosecution because the prosecutor will use that against them.
You don't allow a resignation without making any admission of guilt?
They have to sign an admission. They'd have to sign the negotiated plea agreement admitting to their acts. Now they can resign
To accept
without
a resignation?
Well, they can resign without signing, yes, but I can't force somebody to resign.
No, I understand that, okay. But do you have any arrangement with the district, where there's so much talk now about criminal justice reform, getting cases to trial speedily? I mean, this would be thrown out of a court of law if it pended for this long a time, unless it's a homicide. Do you have an arrangement with the district attorney's office where you're in touch with them periodically, monthly, 2 months, wherever? Where are you on this investigation? What are you doing with this? Because we need to decide what to do with this officer who's sitting here on full salary when DOI has substantiated it.
We are in touch, but we do not tell a district attorney what to do. We don't have the right to do that. So
No, I
we have,
understand that.
Yeah, so
But
we are in touch.
They're putting you in a little bit of a difficult position if all of this is true by being required, and I understand the stand down policy.
Yes.
While being required to stand down pending an investigation that's been going on close to 3 years.
Yes, and so also another thing that we will do if we see that our statute of limitations is coming close, which is 18 months, is we will charge. We will draft and charge the individual in order to preserve the statute of limitations so that if and when the criminal prosecution concludes and we are allowed to then take over an administrative prosecution, we wouldn't have lost the ability to do so.
Okay, so your statute of limitations is 18 months.
Yes.
Most felonies are 5 years. They can take up to 5 years, which is a very, very long time. So you'll go ahead and charge.
We will charge
and
to
then
preserve
just
it.
stay that so that.
Correct. Yes, we'll do whatever we can.
Ms. Hamill, may we add one issue with our particular case?
Sure.
Because we were fortunate enough to convince the federal judge to lift the stay in our case and let us proceed with discovery, we do know that in our case, the city swore in interrogatories that no disciplinary charges had been brought against this officer. In the course of discovery, it was confirmed multiple times that there were no disciplinary proceedings against the officer that had been stayed or otherwise, and of course we're now well past that 18-month period. So we just like to, make sure that all the facts are on the record in terms of considering how best to improve these miscommunications moving forward.
Thank you.
Thank you. Dory Lewis and Kayla Simpson.
Hi, I'll take the time just for Dory and myself. My name's Kayla Simpson. I'm a staff attorney at the Prisoners' Rights Project at the Legal Aid Society. Thank you so much to our colleagues from Cleary Gottlieb for that helpful comment. I'll refer to that client as JG, as I think we did in our letter to preserve his anonymity. And the reason that we have chosen to ground our comments and our contributions in this forum with his experiences and with the experience of people like Jonas is because in a conversation about systems, what we're concerned with is how it actually affects people. Those are the people that we hear from every day. And in many ways, JG's experiences are what too many of those people in DOC go through. Ironically, though, in a couple of ways, of course, he had it better. He had it better because he had able representation. We were able to place his case with Cleary when he reported it to us a few months after. He also had it better, so to speak, because his allegations were actually credited by DOI. We all know that the rates of substantiation are less than 1%, so that's pretty extraordinary too. But the fact of the matter is, it hasn't mattered. We've heard many justifications here today about why, but let's talk about his reality. Nothing has happened to the officer. And I know that we just heard these comments, so I won't go into that again. But it's been years since this substantiation by DOI, and it's extremely unlikely with every passing month that anything will ever happen. He is still being paid $62,247 taxpayer dollars every year. The officer subjected a gender nonconforming gay man to more than 15 incidents of sexual touching in 1 month while he was in PC. The officer didn't just harm him, he also abused other vulnerable persons housed on this unit while other staff and supervisors either willfully allowed it to happen or were just oblivious to the fact that it was going on. I don't know that. But when something like this can happen, I think we have to ask if anyone really believes that these systems that are set in place are adequate systems of supervision and accountability to protect people from abuse. That's why I'm up here today. It's why we've been requesting this hearing. And of course, we're genuinely glad to hear of improvements in staffing levels and backlogs and reporting. All of those things are positive. We're happy to hear them. But we can't lose sight that The goal of Chapter 5 of the board's minimum standards is what its title is, which is elimination of sexual abuse and sexual harassment in correctional facilities. And of course, the requirements in these standards are important metrics to try and capture whether there's a system in place to work towards that goal, but those standards are part of a means to an end. They're not the end in themselves. And we need to acknowledge, I think, that there is still a problem with sexual abuse and harassment in our jails. An advocate after advocate in this room can get up here and tell you the stories that we hear from our clients and their families. And yet we only have, and I'll use the board's number just because I'm not sure about the recent substantiations that Deputy Commissioner Townsend referenced, but we have 8 substantiations reported from 2017 and 2018. Does anyone really believe that there were only 8 instances of sexual abuse or harassment in the city jails in that 2-year period? Whatever the national rate of sexual assault or harassment is, that is too low. Does anyone really believe that officers don't know when their supervisors will come to do rounds? From what we read in the board report from yesterday, captains aren't even necessarily touring once in an 8-hour shift. And the board's audit of the rounding logbooks indicated, I'll repeat it, that 38% of those audited cases, the supervisor walked in, signed the logbook, walked out. Didn't walk around the housing area, didn't engage with the incarcerated people, didn't actually round. And that's so significant. That suggests that that is not an anomaly. It suggests a cultural problem. And if a captain has just come by, an officer who wants to abuse someone in custody knows that they're not coming back for a good long while, and that is a perfect window to do it. Does that seem like supervision that deters sexual abuse or harassment? And the board's audit shows us again the same concerning problems with investigations. Are they interviewing people in designated PREA areas where it's obvious to everyone that a PREA interview is taking place? That's problematic. Are investigators adequately attempting to preserve crime scenes and physical evidence? I guess we'll look forward to the next audit to see whether that information is included in the closing memos. How are investigators weighing who's credible when they are weighing the word of their coworkers against the word of our clients? And not surprisingly, in 70% of the cases, BOC had no idea how decisions about whether to substantiate were made. Although it certainly sounds from our reading of that audit that DOC was quick to jump to a conclusion that a case was unfounded, not just unsubstantiated, but unfounded, in a case where there is no reason to think that it didn't happen. We keep talking about substantiation rates because there is a fundamental problem in the culture of DOC. There is not meaningful accountability, and staff know it. People do not believe they'll get caught, and if they're caught, they don't believe investigators will substantiate, and if they don't substantiate, they don't believe DOC will remove them from employment, and they don't believe DA's offices will prosecute. And if what happened to our client JG is any indication, they're right. So how can we blame our clients when they tell us over and over and over again that they don't want to report because there's no point? We need to not just be interested in checking boxes. Talk to the incarcerated person, check. Reviewed video, check. 1 round per shift conducted, check. Signed a logbook, check. We don't need check boxes. We need to eliminate sexual abuse and harassment, or at the very least, we must deter and discipline it. And I just want to say one more quick word about the recommendations that DOI made to DOC in 2017 that DOC has rejected due to administrative convenience and to cost. I think that's in the letter that's published. These recommendations make sense. Video footage should have to be kept for a year. Incarcerated women should have to be escorted by a male and female officer. Exit interviews should be conducted of incarcerated people by trained professionals so that DOC can find out what's actually happening in their jail when they're no longer so afraid of retaliation. And DOC said they're not going to do those things. That's unacceptable. With all of the well-documented problems the DOC has had in implementing the PREA standards, administrative convenience and cost are not acceptable reasons to ignore recommendations from DOI. Respectfully, we suggest that the board should not be satisfied with those results. We thank you very much for all of your work in this area, both the board and the staff. We ask for even more vigilant oversight oversight that must continue well beyond this hearing, important though it is, because the issues with complete PREA compliance are not going away. Thank you so much.
This is a quick factual
Thank
thing.
Sure.
Your client, the abuse that your client reported, when was that?
It was December of 2015. No. Great.
Thank you.
Thanks.
Thank you. Rachel Herzog.
Hello, good afternoon. My name is Rachel Herzog. I'm here from the Crime Victims Treatment Center, where I'm the program coordinator of the Crime Victim Treatment Center's PREA program. And I'm here to speak about the importance of access to confidential victim services. A little bit of context about our program. We have existed since, the Crime Victims Treatment Center has existed since 1977. We're one of the oldest rape crisis centers in New York State. And we've been running a PREA program since 2013. We provide services to incarcerated survivors across 16 New York State prisons and 2 federal detention centers. So we have very acutely aware of the importance of victim services, specifically in the correctional setting, and also of some of the unique challenges that come with providing these kind of services in a correctional setting. Obviously not everything that we do is applicable to the city setting, but a lot of it is. And one of the things we know is that to make access to victim services meaningfully confidential, meaning that incarcerated survivors are comfortable accessing it, they feel safe accessing it, they feel like they're not going to receive further retaliation, takes a lot of work. It's not as simple as just making a memorandum of understanding with a victim service provider or establishing a program in part of correctional health services, though we're very, very glad to hear that both of those things have been done. We have had to build a very collaborative, complicated relationship with the New York State Department of Corrections and Community Supervision that has had to really be characterized by collaboration, transparency, and willingness to learn from one another. We believe that kind of relationship is possible in DOC, and we really hope that that can evolve, but we have a lot of questions for the department about how victim services are being provided. We do, in our work, sometimes we receive outreach from survivors who experience sexual violence while incarcerated in DOC facilities, and now are seeking our services now that they're in the state system. I'm proud that Jonas Caballero, whose brother came to speak today, is one of my clients, and I'm very honored to have worked with him. I'd like to speak briefly about one other client that I've worked with who gave me permission to share some of his story anonymously today. He was assaulted about 6 months ago in a DOC facility. This survivor had been identified as high risk. He had been placed in protective custody due to his sexual orientation. But somehow the staffing level wasn't sufficient to ensure his safety. And I don't know the reasons for that. I don't know what the staffing was. But he was in a position where he was alone with another inmate, an incarcerated man who had a history of gang affiliation and who sexually assaulted my client. My client says that one of the most traumatizing parts of this experience wasn't the assault itself, but the aftermath, when he was left crying and weeping and reaching out for help, and no one in the vicinity listened to him. And somehow he was unable to get staff response. He was only able to make a report by calling 311. I don't know why there were no staff there, but from his perspective, he was left alone in a hugely traumatizing moment. His case may have been closed, but he received no notification of it, just like Jonas. He's in the state system wondering what happened, wondering if anyone took him seriously or cared. He said, I asked him if there were any words that he wished me to share with this board, and he said, I want them to know that something like this can really break somebody, and it's important that they take care, because this has a real impact. This survivor is a resilient, amazing individual who I'm very grateful to work with, and he's made huge strides in his healing. But he wasn't offered the opportunity to begin that healing during his incarceration in DOC. He requested victim services. He was given a phone number where he left a voicemail, and no one ever got back to him. Someone came to meet with him, but he didn't know who they were, and they didn't identify themselves as confidential. So he wasn't able to start that process right in the immediate aftermath when he could have really used that support. It wasn't explained to him what the process would look like, which each step would be for him. He wasn't offered a victim advocate to sit in the investigative interview with him so he could feel safe and comfortable. These are all things that can not only make a huge difference to someone's healing, but to the reliability of an investigation. We know that when survivors have the chance to speak with someone who they know is on their side, who has no other agenda than to be there for them, they're going to feel more comfortable coming forward. They're going to be able to more fully give information about the assault, and they're maybe going to agree to some of those interviews that we've heard from both the DA's office and the department themselves. Sometimes survivors aren't willing to agree to. And I think access to victim services can be a huge piece in making that investigation possible and successful. I also want to note that this survivor, as well as Jonas, who we heard about earlier, are really strong self-advocates. They've reached out, they've managed to get in touch with me, even though we weren't connected with the DOC. They've sent letters to elected officials, but that kind of burden shouldn't be on a survivor. We heard this about JG also, who was very lucky, who was able to get connected with pro bono legal representation. The process should be transparent. The most vulnerable survivors are now going to be the ones who have the least difficulty coming forward without appropriate support. People with coexisting mental illness, with previous histories of victimization, are all going to have much more difficulty accessing support and making reports if that process isn't clear to them. I submitted a letter to this board with some information about what we've found successful in our partnership with the state system and the measures that we've found to help to ensure confidentiality. I'm not going to go through all of them here, but I did want to note that part of that has really been collaboration between the victim services and the correctional communities. That we come with different perspectives, that we bring different things of value, and being able to work together and acknowledge that each of us have things to learn has allowed us to provide services in a way that is meaningful and that helps survivors to feel comfortable accessing them. We have a lot of questions about the way that the sexual abuse advocacy program at CHS works. I've also included a list of those questions. It is unclear to me how survivors access that program, whether they have an ability to self-refer or whether that only happens after they've made an allegation. So are survivors who aren't clear whether or not they feel safe making a report able to access that support that might help them make a determination? That I haven't been able to figure that out. Other questions, and again, I'm not going to go through all of them now, but what kind of steps are being taken to ensure that access to those services is confidential, that other staff within the facility don't know that incarcerated individuals are working with the sexual abuse advocacy program? Is there a way to make advocates available during investigative interviews? And are staff of that program given the authority to advocate for the safety of their clients? Can they communicate with the department? Can they communicate with DOI to let them know when someone's experiencing retaliation or further risk? These are roles that victim advocates play in many settings, and there's no reason why they can't play them in this setting as well. We also are very concerned and confused about the role of the memorandum with Safe Horizon. A survivor that I worked with called the Safe Horizon hotline after being informed that that was an avenue for sexual assault advocacy, and was told that they don't provide services to incarcerated survivors. So if a memorandum of understanding exists, it's necessary that that partnership be given a chance to succeed, which means cross-training, which means collaboration, none of which we're seeing happen here. We're hopeful that all these kinds of changes may be possible. We have, and as a representative of the victim services community, I also want to communicate our commitment to working with the department and making ourselves available for support in any way possible. Thank you.
Thank you. Sarah Zadie?
Just want to remind everyone there's a
DOC,
6-minute
I hope,
limit here.
Yeah, and I would encourage DOC that if you could stay, because I would call upon the department to really engage some of the folks that came up and spoke. It really is an opportunity not to finger point, but to have some lessons learned that we can improve the process. So, thank you.
Good point.
All right, members of the Board of Corrections, good afternoon. My name is Sarah Zadie, and I'm the Assistant Director of Programs at the New York City Alliance Against Sexual Assault. Thank you for providing us this opportunity to bring our concerns around sexual abuse in correction facilities to you. I'd like to use this forum to discuss the need to refine and supplement the training of the Department of Correction employees according to PREA standards. Founded in 2000, the Alliance's mission is to prevent sexual violence and reduce the harm it causes through education, research, and advocacy. Based on our extensive experience in providing trainings pertaining to sexual assault, we feel we're well positioned to offer some recommendations around the current training protocols at DOC. In order to address the implications of a sexual assault in terms of the stigma around sexual abuse, the incredibly high risks of reporting an inmate or an officer, the effects of trauma and its long-term sequelae, we would first like to consider how these trainings are implemented. While we've heard some clarification on current trainings today, it would be helpful if the board could consider asking the following questions of the DOC. First, who is providing the trainings? Ideally, the trainer would be an independent entity so that there can be an open and honest conversation. Who's receiving the trainings? All levels of staff should be receiving the trainings and their attendance tracked so that it's clear who is receiving which training. Is the supervisor training separate from staff? How frequently are these trainings updated? At what point along the onboarding process of new staff are the trainings provided? How frequently are the trainings offered? What is the mode of delivery? Are trainings completed in one session or are they multi-dose? Are there follow-up options? Is there counseling support available for participants in the event that they feel triggered during a training? How is the impact of these trainings evaluated? Has the board been made aware of any reporting from staff of recognition of warning signs of sexual abuse that they have witnessed? How do you get participants' buy-in other than it being a mandatory training? For any training to be successful, it's important for the participants to recognize its importance. And considering incentives or ways in which staff would appreciate the need for such training would be helpful. What languages are the trainings provided in? While in the process of revising the training curriculum, it would be beneficial to keep the following recommendations in mind. All trainings need to be updated with current vernacular and procedures. Trainings should be provided in person in the form of interactive sessions, not just a video being watched. Staff eligible for training should be identified and their participation in training sessions should be documented. After each training, action steps with timelines should be discussed in terms of how to follow through with the information gained and the skills learned. Concrete measures should be put in place for accountability to check progress. Sexual violence training needs to take a trauma-informed approach because it provides a lens that helps another person gain a better understanding of the survivor's behaviors. A trauma-informed training would allow individuals to be seen as a whole, recognizing how one's life experiences may result in specific behaviors or how one's past experiences may trigger potential reactions. In correctional facilities particularly, it would allow law enforcement officers to be better prepared. Given the power dynamics between inmates and officials, it's also important to recognize how that might play into the abuse and/or reporting in the case of abuse perpetrated by an officer on an inmate. Similarly, the consequences of telling on another inmate or worse, an officer, could possibly result in ongoing abuse or other consequences. Vulnerable populations, often being easier targets, need higher vigilance. A comprehensive trauma-informed training can help correctional officers feel more capable of identifying red flags for sexual abuse, understanding its impact on behavior, and improving the chances of reporting, ultimately with the goal of reducing abuse within the system.
I'm going to ask if there's more recommendations. You could mail those.
I have submitted the letter.
Them? Okay.
Yes. I'm just going to read over the list of trainings that we're recommending, and that's it. Okay. This is the list that we are recommending to complement what's already provided. Acknowledging biases and rethinking stereotypes, power and control dynamics within systems, providing increased vigilance for vulnerable populations, understanding behaviors that may stem from trauma, creating a safe environment space for inmates to disclose abuse, steps that can be taken to minimize retriggering assault survivors, bystander training, legal procedure and ramifications of reporting, effects of non-reporting on a victim, being mindful when working with survivors, supervisor training to support staff while holding individuals accountable, and vicarious trauma. If correction officers were given appropriate information about sexual abuse through comprehensive training, they would feel more equipped to provide adequate support to incarcerated survivors, and we may eventually be able to stop the cycle of abuse within the system. Thank you.
Thank you. Thank you.
Excuse me, before DOC leaves, I'm just wondering if you or someone can respond to the issues that Rachel Herzog had raised about victim services. I meant to ask that, and there's just been so many areas that I wanted to question on. I didn't, and I noticed that it looks like health has left, and they briefly mentioned it, but didn't go into any detail. So it would be helpful to really know right now, and this is something we really looked at in PREA rulemaking, what victim services are offered, when are they offered, what about the issue of Safe Horizons? Is Safe Horizons actually available? Are they actually providing victim services to the incarcerated persons?
So
are those requests and services delivered tracked through DOC?
So I can't speak for CHS, and I really don't want to. I will speak to Safe Horizon. The Safe Horizon information is located on all the inmate education information that they can get in contact with them. And we do receive reports from Safe Horizon about allegations. They track it on their end. When we ask for information for purposes of confidentiality on a written document, they don't provide that to us. But recently, I asked for aggregate numbers, and I believe, I don't have the book in front of me, I believe it was 33 allegations, and I think I asked them for this year. That was reported to them.
My question is whether, I believe you had said that a client had called and they said they don't do the counseling. So my question is, are they in fact delivering victim services in counseling?
Part of the memorandum of understanding, an agency would not get into a memorandum of understanding with another agency unless they were going to fulfill what is said in that MOU.
So that's, a memorandum of understanding is an anticipation. Now the question is, are they delivering the services?
According to the 33 reports that they said that they've received at the beginning of this year, yes, they are.
And do they tell you how many times they meet with the victim and what their services consist of?
They do not give us information about what they provide to those individuals. However, I believe they receive permission from the individuals to report the allegations to us, and then we report that to ID for it to be investigated.
So your representation today is that they have actively counseled, provided victim services to incarcerated persons while they're incarcerated through Safe Horizons. Is that correct?
My testimony is we are in an MOU with them to provide whatever the MOU indicates they will provide. That is my testimony. I can't speak to exactly what they're doing because I don't work for Safe Horizon, right? Whatever the MOU says that they're going to do, we believe that they are doing it.
So do they get referrals from you, or do people just go to them and reach out to them and say, I need services? How does the MOU get implemented?
So there, like I said, the information for Safe Horizon is on the inmate education information that they can get in contact with them. I believe, I forget the name of the agency, there is another pamphlet and or card that is given to an individual from ID, but I cannot remember. We don't have an MOU with them, so I don't know what they're supposed to provide to them, but that is another advocacy avenue for anybody who is reporting an allegation.
So let me just understand this, right? So when an allegation comes before you and you start the investigation and you go and you talk to the person, at that moment, DOC does not say, here is a victim services organization that you can reach out to,
yes, they do,
that we have an MOU with to receive services. That does not happen. That does not happen, right?
That does happen, because it also, thank you for reminding me, it is part of the coordinated response plan as well, that they get in contact with someone, a victim advocacy group. So it's medical, mental health. We did not take away, the standard doesn't require ministerial services, but we didn't want to take that away from them, and we added on an advocacy group that can speak to the victim or a potential victim. Okay.
So we'll have some follow-up questions that we'll send to you.
And Ms. Herzog, Ms. Herzog and I did speak, and I gave her my information as well as my colleagues' information for her to email us, and hopefully we can have some really, really good dialogue in very near future.
Does the MOU require the department to monitor the services provided? I mean, I know you said that you know the MOU existed and you assume that the services are being provided, but
I don't assume.
So do you know they are, or you know they're not?
I would like to think.
You would like to
that
think.
Safe Horizon, that's right. Okay. I would like to think
Similar
that
to
Safe
assuming.
Horizon, no, we don't want to assume. I would like to think that Safe Horizon is definitely providing the information that we contracted with them
Right,
for.
but I'm saying, does the MOU require you to monitor that or substantiate that or to confirm it at some point?
No, it does not, but however, I get in contact with them and I ask them, have they received reports? And they have told me that they have received reports. And I know that they've received reports because when an allegation comes in and they're reporting, we also hear it from hear it on our confidential hotline. They've called the confidential hotline to say, this is Safe Horizon. We had an allegation that someone reported to us, so we can start the investigation. So I know that they're advocately working with potential victims.
Right. Okay, but not to beat a dead horse. I mean, you said you have a contract with them. Whenever you enter
The
a
agreement,
contract,
the
you want to
MOU.
make sure that what you've contracted for is being delivered.
Yes.
So you'd like to think it's being delivered, but it doesn't sound like you know for sure.
I know that they're receiving complaints.
Right.
What
It's
they
the
are doing.
counseling I want to know, whether they're actually counseling and available to counsel.
I can,
ongoing, not just taking
without
the
getting
complaint.
into details about what they're providing for individuals for obvious reasons, I can ask them, is there actual counseling going on
Yeah,
for
I
those
think
individuals?
that would be a
But that
basic
is what Safe
question.
Horizon, that's what they do, and that's what they, as a former prosecutor,
She's
I know
saying that
Safe
the client
Horizon.
called and they said they
I
don't do
understand
it.
that, but also as a former prosecutor, and Judge, Safe Horizon, when you give it to them, when they have an allegation, when they're speaking to someone, that is part of what they do. Part of the MOU with us is that they give us the report.
I know too, but I don't want to assume that that's what they're doing for our Rikers population.
Then I will
That's
ask.
what they do outside. Do they actually come onto the island and visit in person, or is this all by telephone?
They don't come on the island, and that's why the board was asking for CHS to have another advocacy who can come onto the island.
Right. And so is there a confidential line for this engagement that you think is occurring?
Yes.
Okay.
You're welcome.
Okay, we have a few more people. Brittany Cooper.
Hi.
Hello, Brittany.
My name is Brittany Cooper, and I'm a social work intern at Brooklyn Defender Services and the Jail Services Unit. For the past 7 months, I've visited clients in New York City jails to respond to various safety, medical, and mental health concerns. Recently, one of the pressing issues that our clients face is related to PREA standards, specifically regarding housing based on one's gender identity. As a result of this issue, our clients have endured various forms of mistreatment in the jails. BDS client, who I will refer to as Ms. T, was placed in a male facility despite identifying as a transgender woman. She was never informed of THU at the time of intake. When she did learn about the unit through word of mouth, she immediately inquired about it with DOC staff, only to be told it would be worse. Ms. T used that information, trusting the officer's judgment, and decided to stay in the male facility. The following is her testimony describing her experiences sleeping in a male facility as a transgender woman. Other housing areas should have been mentioned. I would like for my pronouns to be honored no matter what facility I'm in. When a person comes to the COs with concerns of harm, I should be taken seriously, not laughed at, not sent to protective custody. Diffusing the situation should come first. We should get the same respect as any other woman. When it comes to clothing, we should be able to get correct size undergarments, like every other female. We should also get feminine hygiene products such as shampoo, conditioner, suppositories, Preparation H, enemas, and cream for rashes. Also, my medical needs should be taken seriously. I would like to talk to doctors that understand my concerns in regards to body changes and hormone therapy. There should be a hormone specialist, and they should be accessible no matter where a transgender person is housed. The requirements to work should not be straight male. I am a human being willing to work the same as the next man. I should not hear remarks like, "You are not on the corner," or "It's a privilege to work, don't take it for granted," just because I would like to work. And when I do work, I should not be harassed by others and forced to quit. I know I'm here because I did something bad. I know my rights and wrongs, but these are the basics of treatment for someone like me. Based on Ms. T's testimony, one can see that housing consistent with the individual's gender identity is important to the safety of our transgender and non-gender conforming clients. BDS asks the board to take into consideration the consequences of not properly housing an incarcerated person by their gender identity. We encourage the board to visit and speak with people detained and sentenced in our city jails, those with direct personal experiences, in order to improve the housing placement process for transgender and gender nonconforming people. Thank you.
Brittany, is she still in a male facility now?
To my knowledge, yes.
Do you know what, if you could give us the facility, and if she doesn't mind, the name?
I would have
So
to
we could
consult
look
with my
into it?
supervisor since I am an intern, but if I'm able to, I will.
Okay.
You're welcome.
Simone Sprigg?
Good afternoon. My name is Simone Spierig, and I'm a jail services social worker at Brooklyn Defender Services. I want to thank you for the opportunity to speak today at today's hearing and share with you some of the experiences of clients at BDS, clients whose voices are often marginalized and unable to be heard. I also want to thank DA Clark for raising awareness earlier around the need for more video surveillance and cameras. My testimony will go into more detail around that issue. Our office is deeply troubled by the department's lack of accountability within the department to end sexual abuse. Thousands of people report sexual abuse each year in our city jails, and many more incidents go unreported. I would like to share with you a story about a woman our office has discussed with the department and the board many times over the years. We repeat it with you today because her story represents potentially thousands of other people incarcerated in our city jails. Earlier on the day that Miss A was raped, she had appeared in court with her lawyer. After her appearance, she returned on an early afternoon bus back to Rikers Island. Miss A was raped by a male officer at the back of the bus in a parking lot on Rikers Island, all while the driver of that bus sat and watched. When she reported the incident, the bruises on her wrists and thighs were clearly visible. The two officers on the bus held Miss A against her will and tortured her without anyone questioning the missing bus, the missing officers, the missing woman, or why it took more than 10 hours for Miss A to travel from court to her housing unit. Her story propelled our office to demand the installation of cameras on buses during the 2016 rulemaking. It became a tiny victory when the board approved the condition and required the department to institute a one-year pilot program to install video cameras on all department transportation vehicles and then report back to the board. Unfortunately, as far as the public is aware, the department has yet to comply with the board standards, and the deadline imposed by the board was nearly 2 years ago. And when questioned by the board or the public, as we saw today, the department merely cites unspecified delays. Though we appreciate that the department faces significant pulls on its resources, delaying the effort to end sexual assault is simply unacceptable. Further, while the board's efforts to hold the department accountable are warranted and appropriate, we urge the board to go further. The fact that the board has issued the department a notice of violation, one of only 2 ever issued, for failing to comply with the video camera requirement is an important first step. The fact that the board took such a significant step indicates the troublesome nature of the problem. Nonetheless, we urge the board to take additional steps, including conducting further investigations and demanding regular progress reports from the department. This is one example that highlights the importance of transparency on behalf of the department and the board. Additionally, we have grave concerns over whether the department is capable of competently investigating sexual abuse in DOC facilities or vehicles. Through reporting, the board has already established that the department's investigation practices are deeply flawed. Even more troubling, the department has so far been incapable of installing cameras, a step that would deter abuse and provide a layer of safety for incarcerated individuals. We urge the board to hold the department accountable for its inaction. The lack of willingness by the department to abide by the minimum standards is detrimental for the city and puts the incarcerated population at great risk. We have serious unanswered questions about training, the competency of investigative staff, and the department's ability to keep people in its custody safe. These crucial failures by the department only underscore the city's lack of concern to keep people in its custody safe and disregard the need for voices from those incarcerated to be heard. Thank you for your time.
Quick question, was that crime reported? And are you following up? Has anybody followed up with your clients?
So I wasn't currently working for BDS then. The incident happened in March 2015, but I can have my supervisor follow up with you about that, who is more aware of the situation.
Thank you.
Yes.
Deborah Lola.
Good afternoon. I have to say I'm disappointed that the majority, if not all, of DOC is gone, as much of my testimony is very much conflicting with the testimony that Assistant Commissioner Gilardi provided. And I imagine that the board would have some clarifying questions for them. My name is Deborah Laloy, and I'm the LGBTQ client specialist at the Bronx Defenders. In my work, the Bronx Defenders provides holistic public defense in the Bronx, and I work in the special project called the LGBTQ Defense Project. As part of my work, I represent all of the transgender incarcerated clients that my office represents. Much of our time and resources are spent advocating for our transgender incarcerated clients who are currently continuing to experience a lot of harassment and abuse while they are in the custody of the Department of Corrections. First, I would like to thank you for your continued attention to this important topic, about which I have testified before the board in the past. I would also like to acknowledge that since this past summer, when the THU was transferred to Rose M. Singer Center, the conditions at the THU have improved significantly. But those improvements are only impacting our clients who are in the THU. The overall consensus from women who are housed in the THU is that it is much safer now and more affirming than when the THU was housed in a men's jail. However, because of the limitations on THU eligibility, many transgender women, as you have heard, continue to be housed in men's jails, whether it is in protective custody, general population, or solitary confinement. They all face the same mistreatment. They are misgendered, harassed, and are often the victims of sexual violence and assault. I personally have several transgender women clients that are currently in men's jails, in general population, in protective custody, and in solitary confinement. Today, I would like to discuss the ways in which the THU should continue to improve, but I'd also like to highlight the experiences of incarcerated transgender women who are not in the THU. Despite the improvements in the THU, there are still many unresolved concerns. One of the issues that we have observed is the way DOC handles reports of sexual harassment or abuse within the THU. When a woman in the THU reports being sexually harassed, she is removed from the THU and transferred to a men's jail. The policy of removing a victim of violence from the environment where they experience that violence makes sense in other contexts, but it does not make sense in this context. It is extremely harmful when enforced in this context, because when a transgender woman reports being a victim of violence in the THU, they are removed from the unit and placed in a men's jail, where their safety is at risk. Essentially, women are being punished for reporting sexual harassment and abuse in the THU. This practice has already had a chilling effect on the women housed in the THU, as many of them are now afraid to report sexual harassment and abuse within the unit, because they've seen what happened to other women who have made those reports. The THU is also not equipped to house women who require a higher level of care, such as serious medical treatment, detox or drug treatment, or mental health treatment. For transgender women who require this level of care, the THU is not an option. Transgender women who do require this level of care are always housed in men's jails because they cannot access the care that they need in a women's jail, despite the assertion that was made earlier that transgender women are housed at Rose M. Singer. In our experience, that is not happening. While the THU is an incredibly important unit, the main reason I am here today is to address the safety risks to our clients who are not in the THU. The reality is that when a transgender woman is not in the THU, she is in a men's jail. Some of those women are in protective custody, some are in general population, some are in solitary confinement, but they are all in men's jails. Most of the women who are in men's jails are not there by choice. They are there because the Department of Corrections did not accept them into the transgender housing unit. They did not know that the transgender housing unit was an option. And even worse, they were discouraged by officers to apply for the transgender housing unit. The department testified earlier that PREA officers fill out, I believe they called it a transgender and intersex form. My experience from my clients who were brought that form to fill out and sign by PREA officers is that PREA officers are telling them it's less safe for them to be at Rose M. Singer, and so they shouldn't request to be at Rose M. Singer. When transgender women enter into DOC custody, they are supposed to be given the option of applying to be housed in the THU. However, most of the transgender women we represent who apply to be housed in the THU are not accepted into the unit. There continues to be a lack of transparency about the process that determines who is accepted into the THU and who is not. And I know that the report that the board published highlights some of this lack of transparency. The two most common explanations that the department has provided for not accepting my clients into the THU are one, a history of violence, and two, the DOC's assertion that they are not actually transgender. The department has often cited to the criminal record or disciplinary record of women who they reject from the THU as a justification for their rejection. It is important to acknowledge the fact that because of the disproportionate attacks and violence against transgender women, they are often placed in a position where they need to defend themselves from violence. And as a result of that, they are often the ones who are criminalized for their own self-defense. Another extremely common way DOC attempts to justify rejecting transgender women from the THU is by asserting that they are pretending to be transgender. Excuse me. The department often expects us, as advocates and attorneys, to prove to them that our clients are transgender by digging into their medical records to find evidence of transgender-related medical treatment and sharing our clients' personal information and medical history with DOC. What the department fails to recognize in requiring this type of proof is that not all transgender people transition in the same way, and that does not make them any less transgender.
Deborah, can I ask you to just get to the high points?
Yes.
And I want to make a statement for everybody, because I think part of this, we have to work together. And so if you can just give us the high points, then I want to make a recommendation specifically to you, but to everybody else.
Absolutely. In conclusion, many of these issues that I've already addressed would be resolved if the department housed transgender women with other cisgender women outside of the THU. When a transgender woman is not accepted into the THU, she should have the option of being housed with other women at Rose M. Singer Center, but our clients are never given that option. Until the department starts to treat transgender women as women And until it actually makes general population, protective custody, and other housing units, other than the THU at Rose M. Singer, accessible to transgender women will not be safe in DOC custody, and they will continue to experience the extreme levels of harassment and violence. Thank you for allowing me the time and opportunity to testify about this important issue on behalf of all of my clients who have survived such violence in the custody of the Department of Corrections.
Thank you, Deborah. So here's my recommendation, is if anybody, you heard the department testify today about their new protocol and processes. If you have a client who is experiencing something different than what they said, please let us know, because that's something, even though it's one case, that's something we can look into with the department. And I think the more we push up against, if there are examples that are happening in real time where it's not, people are not being treated according to their own policies, we need to be able to hold the department accountable, and we could push forward one case at a time. So if you have specific cases that are right now, please let our staff know. We could follow up with that.
I believe the board is already familiar with some of my clients' cases, but I will definitely inform you of the ones that I have not yet shared.
Thank you. Thank you, Deb. Marlon Bolden. Thank you.
Hi, my name is Marlon Bodden. I'm an attorney at the Legal Aid Societies. I apologize for my cough drop. Legal Aid Society Special Litigation Unit. First, I want to thank whoever was responsible for bringing the Westchester County team here to speak today, because they specifically spoke about an issue that was not really picked up by anybody, and is the reason why I'm here to speak today. That has to do with strip searches of detainees before visits, and also the routine use of strip searches. Now, as we all know, the purpose of the board's standards is to stop an environment of sexual abuse and harassment. Yet, unnecessary strip searches, and there is no question that strip searches before visits are unnecessary. Because as the men from Westchester County said, even the New York State Department of Correction in the entire state system does not perform strip searches before visits. These unnecessary strip searches create a degrading atmosphere where sexual harassment is rampant. Many of our clients are frequently sexually harassed during strip searches and tell us that strip searches are humiliating, embarrassing, and dehumanizing. Our clients report that correction officers often laugh and make sexual comments about their naked bodies, usually about the size of their breasts or genitals. And I have just a few examples. Since 2016, when we received over 100 complaints from women who had been jailed at Rikers but were then comfortable enough to write us from Albion State Prison, we have now interviewed to date about approximately 30 more. So we have 130 complaints about women and men regarding being strip searched routinely in their housing areas, but also before visits. And the most common complaint, as I said before, and I'll give you some examples now, have to do with sexual harassment. John Doe number 1 was sexually abused as a small child. So he relives the abuse every time he is strip searched. He always obeys the correction officer's orders to strip naked, squat twice, facing the CO and facing the wall, lift his scrotum and penis, and cough. COs have beaten him when he complained about being strip searched. COs, in the presence of other inmates and officers, have laughed at him after saying he has a small penis. He is strip searched before each visit, but he still has to go through a metal detector after being strip searched before each visit. And this applies to all of the people with whom we spoke. And John Doe number 1 has limited his visits to only one family member just to avoid being strip searched as often. Jane Doe number 1 is a sexual abuse and domestic violence survivor. She says there's no privacy where the strip searches take place, and other detainees, including, and my colleague Dory Lewis wrote to you about this. I've had 2 women at Rose M. Singer complain that there's another detainee who works in the strip search room and can see all of the other detainees stripping and naked. So that must be stopped. So Jane Doe number 1 told me, and this is another really important complaint by women who are menstruating. Apparently, menstruation is a time when COs think that this is a good way to humiliate women for being on their periods. And we've had multiple reports about women menstruating during strip searches. Once, when Jane Doe number 1 was menstruating, she was strip searched before her visit. The CO told her to take off her menstrual pad, and when she did so, some blood spilled on the floor. Now, this is almost verbatim. 3 years apart, we had an almost verbatim complaint from a woman who was at Albion at the time. The CO, when the blood got on the floor, the CO said, "You'd better clean that shit up. Go to the bathroom and get some paper towels." Jane Doe 1 obeyed, got paper towels from the bathroom, knelt on the floor, and cleaned the blood. But after that incident, she told her family and friends to stop visiting her. She only asked for visits about 4 months later because she had become clinically depressed. Jane Doe number 2 also is a sexual abuse and domestic violence survivor. She reports that cameras in the strip search are focused directly on the women when they are naked. So in other words, I understand the need for a camera that should be focused on what's happening where the woman, the naked woman, is behind some sort of partition, but the CO is visible in the camera. That we understand. But I don't understand why you need a camera to record a naked woman's body. That has to be investigated, and that has to stop. Because my concern, as well as my client's concerns, are that these are being used for voyeurism. So Jane Doe number 2 said that, interestingly, she's not always ordered to take off all her clothes. Some COs tell her, "Oh, you don't have to take off your blouse, your top. Just pull up your bra and shake your breasts." Now, in terms of the men, almost all of them said there's some comment about the size of their penis. John Doe number 7 told me that correction officers often make comments about the size of his penis, such as, "He's got a big one," and "He's got a wide one," accompanied by laughter. And John Doe number 12 said that during a strip search, when other detainees were present, a correction officer pointed at John Doe 12's penis, then said to another correction officer, he's not circumcised. Both correction officers laughed. One of our clients reported that when he was being strip searched, and there was another detainee also being strip searched, a correction officer ordered the other detainee to pull back the foreskin of his uncircumcised penis to see if he was hiding contraband. It is clear that strip searches before visits serve no legitimate security interest. The Legal Aid Society is therefore calling on you, the Board of Correction, to issue a standard ending strip searches before contact visits. And we want that standard to be issued immediately. People are hurting right now. As you know, many detainees are domestic violence or child abuse and adult abuse survivors. So every time they go through these strip searches, they are re-traumatized. So we're asking you to issue this standard immediately. And of course, I guess there's nobody here from DOC, but we will be writing DOC as well, demanding that they end these strip searches before contact visits. And you have the testimony of the gentleman from Westchester County, but if you check with state docs, they will confirm that in the state prison system, there are no strip searches before visits.
That's right. Thank you, Marlene.
Thank you.
Gonna ask, we have three. Oh, okay. There, I was just informed that there is DOC staff here, so they are aware of your comments.
And we will discuss it with them.
And we will discuss it with them as well. Thank you. So I'm going to ask to speed it up, but I want to hear from everybody. We have three people from the Sylvia Rivera Project, Myra, Mike, and Savannah to come up. And Hannah, yes.
I just want to say, so we are here in part because we have 7 testimonies from people inside the transgender housing unit to read. Yes. So it would be really great if we could actually have the 6 minutes each so that we can have their voices here.
Yes, we would love to hear their testimony. Yes.
Okay. Do you want to go first, my love, or do you want me to go first?
No, go ahead.
And did you send that testimony in?
I was sent in this morning.
Okay, you can send that in, that would be great.
So my name is Mick Kincaid. I'm the director of the Prisoner Justice Project at the Sylvia Rivera Law Project. Since September, I have been visiting the transgender housing unit twice a month, and since March, I have been given access to what I have been told is called the transgender housing unit integrated twice a month. So I'm at Rosem Singer every single week, often for 4 to 5 hours. The numbers that were given by the Department of Correction don't align with what I have seen myself. The last time I was in the transgender housing unit, there were 10 women there and 2 women out on court, so 12 women in total. There were 3 women in the transgender housing unit integrated. The rest of the women in that unit are 50 and older, so it's still a vulnerable populations unit. It's not a general population unit. I don't have any access to the new admissions intake, and in fact, I only know of one person who's been through the new admissions intake, and she's standing next to me. And so that even though they say that that's been there since October, none of the women in the transgender housing unit or the transgender housing unit integrated have come through that unit. And then I just want to point out an ongoing concern, which is that transgender men continually are counted as transgender women. And it's a particular...
I'm sorry, say that again?
Transgender men are continually counted as transgender women. When Commissioner Yolardi gave her testimony earlier, she said there were 26 women at RMSC. What she meant is that there were 23 women and 3 men. And there's more men than that. So it's very personally upsetting as a transgender man to continually see that the Department of Corrections doesn't seem to understand these identities or take them seriously. And I would also add intersex to that category. There was an intersex man who I worked with extensively in 2017, and I testified to the board about that. He was housed in a men's jail, and against his wishes moved to the female jail. So I feel like there's a lack of understanding and a lack of knowledge. All right, so I'm going to just briefly read the highlights of my testimony. So similar to the assessment of the THU, I think that there should be considered an assessment of the intake unit at RMSC, including the numbers and the identities of the TGNCI people there. Commissioner Ilardi said that anyone who was female identified would go there. I don't know whether or not transgender men are being considered for that unit, or gender nonconforming or intersex people. So I think that a study of that unit would be very helpful. The lack of transparency that Deb mentioned is a theme. The Directive 4498, the transgender housing unit, is distribution A, meaning it is not available to incarcerated people or to the general public. It was last updated in December 2014. In 2015, I and other advocates were told that they would create a publicly facing document that would just have security protocol redacted. That hasn't happened, and I've had no updates about whether or not that would be happening. But even if it did happen, it's unclear that the directive would actually accomplish anything if it became public facing, because it's incredibly out of date. It's a good thing that it's out of date. It's out of date because the THU moved to Rose M. Singer. So that's fantastic. But it also means that there's no governing document. And that means that when people, apply to the THU, or I guess fill out a form now, it's no longer an application, it's a form, and they sign that they're going to abide by all the rules and regulations, they don't know what they're signing. And the transgender housing unit right now, as it's currently conceived, houses transgender women, and in my experience, also trans feminine, gender nonconforming people, and it isn't open to transgender men or transmasculine people. And all of the transgender men I know at Rose M. Singer are in protective custody. None of them are in general population that I know of. So Directive 449A should be updated and made public. These updates should include the option for transgender men to be housed within the THU or the THUI, and should remove protective custody at RMSC as the default placement for transgender men. I also think that DOC should work with advocates to create a Know Your Rights material that all TGNCI people should receive at intake and should be available in the law libraries of every single facility. To build off of another comment about the Safe Horizon thing, so I go to the THU and the THUI every single week. I've never seen anything about Safe Horizon. I've also never seen anything about the board. So there's no information. There's a possibility that it's in the bathrooms. I don't go to the bathrooms. But it's not in any of the area. It would be very simple to put up a poster and say that the board and Safe Horizon exist as resources. I also want to echo what Deb said, that it appears to me that the housing placement of transgender women seems to be intake at a men's facility, then possibly move to THU, and if they have a difficulty at THU, they move down to THUI, and if they have a difficulty there, they go to a men's jail. There doesn't seem to be anything where they go to protective custody at RMSC, where they go to general population at RMSC, where they go to a drug treatment unit at RMSC. It appears to be the THU, the THUI, or a men's jail. And so I also say that part of this is the issue that I think a lot of DOC staff have varying knowledge about the THU and about housing of transgender people in general. I've had employees tell me that the THU actually exists at Brooklyn House, when in fact that's a PC unit that just happens to have a lot of transgender people in it. I also had employees tell me that the THU is only by a judge's order. So there seems to be a lot of
by what?
A judge's order. So there seems to be a lot of misunderstanding. I don't think it's done out of ill intent. I think it's being done because people aren't educated about it. One of the testimonies by Ms. Medea Sidney, which is attached here, speaks to this. She mentions that she thinks that the officers weren't informed that transgender women were going to be moved to Rose, and so have had just varying reactions to it. So I think that DOC should work with local advocates and experts to create guidance for housing of TGNCI people from the point of intake until release, and this guidance must follow the minimum standards and lay out the reality that TGNCI people have the same rights to access programming as their cisgender counterparts, and that the THU is one option among many. And this guidance must be publicly available, otherwise it won't be helpful. And then finally, I want to follow up on what was said by so many people, which is the lack of faith in investigations. When I've been interviewing the women in the THU over the past 2 months to prepare for this, and everyone I spoke to said that it's not worth filing a PREA complaint. And there are 2 reasons mentioned for that. One is The investigation simply wouldn't be taken seriously. DOC already sees transgender women as suspicious and as troublemakers, and so reports filed by transgender women are simply not investigated or not taken seriously. I will mention that all these women have talked to me about how someone, either a PREA staff member or a DOI member, have come and interviewed them, but that was the end of it. And the interview is usually between 5 to 10 minutes long. So last April, I testified about a friend of mine and a transgender woman who was at AMKC, raped. She advocated for her move to Bellevue. She was returned to AMKC and she was raped a second time. Her story is well known within the THU. And this is the kind of experience that the DOC has to get over in order for them to actually have people believe that it's worth reporting. Because right now, the general idea within the trans population that I know and I work with is that if you advocate for yourself, you will be punished. That she was moved back to AMKC because she advocated for herself, and that second rape was purposeful. Likewise, and Deb said this as well, that I have had at least 3 clients since September moved out of the THU after they reported feeling sexually harassed by cisgender women. These 3 were all transferred out of the THU and to men's jails. And so, in addition to the first piece, which is reports by transgender women not being taken seriously, the second piece is if you report, you will be transferred out of a safe housing. So clear and public housing standards for TGNCI people should assist in ensuring TGNCI individuals to not fear being transferred out of a gender-affirming unit due to reporting sexual harassment or violence. In addition, however, DOC must take concrete steps towards hiring more investigators and creating clear guidelines concerning protections for any individual reporting violence. During investigations, DOC must record contact information for individuals should their cases carry on after their release. And I just want to close by saying that I really appreciate the 7 women whose testimonies are going to be heard. Even the shortest one of them happened only after hours of discussion and crying and talking things out and connecting to resources. And it's incredibly brave of all of them to have shared their stories. And everyone who's in the audience today who is a survivor, who loves a survivor, I thank you for being here because it's very, very hard to relive all this. Thank you.
Thank you. Questions?
Hi, my name is Hannah Walker. I'm the director of the Survival and Self-Determination Project and a staff attorney at the Sylvia Rivera Law Project. I'm going to be reading 2 testimonies from women inside city jails as they could not be here. The first is from Naomi Peterson. My name is Naomi Peterson. I am a young black transgender woman. The following is my testimony for the board. I filled out 5 to 10 forms saying that I was transgender. Maybe some of them were THU applications, maybe some were medical. I don't remember, there were so many and I said it over and over. I was at MDC and then another men's jail. I don't remember the name, it was on Rikers. When I was on Rikers, I was transferred to a house with gang members, Crips. Someone called 311, I don't know who, and I got transferred to RMSC. At the men's jails, they kept saying, he, and I said, excuse me, I'm a woman. And they say, we aren't used to you. I know that's BS. We've been inside before. It's not like they never locked us up before. I know I'm easily manipulated. I'm 25, I have ADHD. I'm so scared of the men and how they manipulate me. The THU is a lot better, but even here, escort officers use the wrong names and pronouns. They say he, she. They call me by my boy name. When you need something from them, they ignore you, or they'll laugh and carry on with the officers and ignore you. They threaten to mace you all the time. If we argue and disagree, they say, I'll press the red button and get the turtles on you. I don't understand a lot of things. Reading is hard. I wish they would just slow down and be nicer. And then the second testimony is from a young woman named Brooke, who was housed at the THU in October 2017 and wrote a really fantastic essay that we've published, and she gave permission for us to use it here. As the officer unlocked my cuffs, I was dazed by the bright, blooming pastels of Rosie's intake unit. I'm sorry about that earlier, she told me. I've had my days with racism too. She was black and a lesbian, and one of the very few friendly faces I had seen in the last week. We had spent the last 2 hours together on a rickety steel DOC bus. We had just stepped off a 2-hour bus ride with a man in the back seat who called me all the usual slurs. Tranny, cocksucker, faggot. I'd become numb to this language from daily beatings in the Brooklyn men's prison. A man in the back seat had reached the end of his rope. I'll snap your neck, I'll snap your neck, I'll snap your neck. He was attacking whomever he could, which often meant the tranny in the front seat. The officers in intake were laughing around the central dock. Step through here, miss. I passed through the metal detector with a dull sense of relief. I knew I was finally safe. The women here treated me so gently. A nervous nurse actually apologized to me when she found me on the toilet trying to bring me dinner. I spent the last week in the Brooklyn men's prison. For the first few days, I hid in my 6x9 cell, sleeping or feigning sleep to avoid the men held there. I had regular visitors harassing me through my cell bars. "We don't want any gays on our floor," was a phrase accompanying every interaction. I pretty quickly stopped talking to people. I tried answering questions about being a transitioning woman and was universally met with laughter and listeners telling me how crazy I was. People asked me if my tits were real, what my genitals were like, how I like to have sex, even after I stopped responding from behind my bars. I remained a sideshow attraction. Men continued to shout through the bars, wake me up by slapping my feet with a towel, take things off my table, and one incident where someone tried to rip my property document from my hand. I waited awake in the night for hours for an officer to pass so I could request transfer to protective custody or a trans unit. Most officers shrugged me off and continued making the night rounds. Some told me to wait for a captain and left. I spoke with a handful of captains with concerns about my safety. 1 or 2 later sent a transfer request document. I think most wouldn't do anything because the jail was too full. During the 24-hour intake, I had been in my own cell for a few hours, but mostly held in larger units with men. It was easier to blend with a baggy brown shirt enveloping my chest. Rosie's is friendly. It's the exception that an officer misgenders me. I only got gendered correctly 3 to 4 times in the men's prison, mostly by nursing staff. And almost every officer has listened to my concerns. Again, the inverse of Brooklyn House. I have easy access to social programs and medical treatment. I did not have phone use for the first 5 to 6 days in Brooklyn, meaning all these pleas for better treatment fell on the deaf ears of staff. Thank you.
Hello, my name is Mira DeYoung. I'm a legal intern with Sylvia Rivera, and I'm going to be reading testimony from 3 individuals who are in city jails and could not be here today. Okay, the first testimony. I would like to withhold my name. I'm a 26-year-old biracial transgender woman. The following is my testimony for the board. Many people address trans women about their sexuality. That's none of their business, and it's very sad that the law does nothing to protect trans women from transphobic behavior. What should be done differently is to simply respect us as people and not what they have assumed us to be. Many NYC jail employees and volunteers have abused their power to include their own religious and personal opinions when dealing with any LGBTQ persons, especially transgender women and men. People are paid to do their jobs without phobic behaviors, and they should truly focus on their job and not their sexual preferences or religious upbringings. I have never been raped, but I hope that the persons that apply for jobs associated with healthcare will treat sexual violence victims of all creeds and sexualities fairly and justly, without judgment of said cases and/or persons. When a pat frisk or a strip search happens, only some people will ask you if you have a preference of officer for the search. This is a very tragic situation. They are insanely disrespectful. Some of the men will feel on the shape of your body and completely disregard the pat and frisk actions and laws. Employees, contractors, and volunteers with the New York City jails should simply treat everyone with respect and kindness. Policies that should be used are the gender-affirming policy. People who may have their loved ones working with them are highly dangerous persons. Persons who work in law enforcement should have a mandatory training class on all phobic subjects, including sexual, racial, religious, and gender. Here is the second testimony. My name is Jeannie Din. I am a 60-year-old Asian trans woman.
The following is my testimony for the board. I am in the female facility now, and the officers call me Jeannie, and female officers pat frisk me, but I am very scared because I will go to prison upstate. There, I will be pat frisked and strip frisked by male officers. I would like to be pat frisked or strip frisked by female officers only. When I have been inside before, like at upstate, some officers would call me Mr. Din. I wish they would call me Miss Din or just Din if they can't say Miss to me. And this is the third testimony. My name is Miss Kitty Jane Rotolo. I am a 55-year-old white trans woman. I identify as straight and as an advocate. The following is my testimony. I will honestly say that the treatment of all transgender people has gotten better since the PREA law has gone into effect. The facility should always practice being fair and impartial as opposed to prejudging us all. The powers that be have become extremely conscious that any and everything that constitutes sexual misconduct is a touchy situation. And now they are threatening to lock us up and write a ticket for something as silly as patting someone on the back. If they're really enforcing this with jail time, then the COs will absolutely think twice about practicing unprofessional behavior. I have experienced pat frisks in both male and female prisons and jails, and by both male and female staff. The state of unprofessionalism goes individually. I tend to experience more professional behavior with male officers. The pat frisk in itself seems to have improved over the last 3 decades. It currently seems to be very professional, courteous, yet thorough. They use the back of their hands to actually touch you, and it leaves less room for abuse, so that is good. They literally used to squeeze our breasts, and now they aren't as severe anymore. I attempted to access health care when I first came through corrections, simply concerning my own lifestyle, in asking for an HIV test. I had a hard enough time trying to rid the medical staff of ridicule and shame. Medical staff is related to security staff, mostly through marriage, so the confidentiality clause almost always gets violated, mostly through nurses disclosing our status to their officer spouses. This in itself is a violation of the worst kind, and more times than not, the officers share our status with the inmates. After suffering injuries pertaining to sexual violence in both upstate prisons and jails, I was just told to go F off. When I would report an incident of sexual abuse, it frightened me immensely. One time, it was after I was literally raped by a gang of prisoners. They would respond with such unsupportive behavior. The institution should practice equality and be aware that every human life is of equal importance. The institution practices prejudiced, biased behavior, which is not legal, nor should it still be in place. Thank you.
Hello. I was incarcerated from March the 22nd to approximately 17 days after. And for the life of me, I couldn't understand why this happened to me because I did not do this crime. And now I know why, because I was meant to. I did not get indicted, thank God, and I'm able to really understand and grasp the level of chaos that's going on in Rikers Island. They did, in fact, take me to Rosie M. Singer's facility from the moment that obviously, because all of my identification, all of my legal documents say female. There was no reason for them to oppose, or, there was no reason for them to even suspect that I was trans. First of all, I would like to lead with the fact that they are falsifying PREA intake documents because they're not using the protocol, which is self-identification. When they asked me if I identify as trans, gender, non-conforming, or intersex, I told them no. I identify as female. They checked transgender woman prior to even having strip searched me. So there's a witch hunt going on at these facilities with transgender people it's self-identification. If you don't identify as transgender, because I personally did not want to be housed at a transgender housing unit. I don't feel any need to be around. I don't agree with segregation. I think that segregation at any level it reeks of, I think, George Wallace in my mind. We cannot make progress and make real progress if we continue to learn nothing from the 60s civil rights movement. We cannot continue to segregate people. We cannot continue to target people. We cannot continue to claim that we stand for equality and stand for integration, because integration is not segregation. Any kind of segregation is wrong. Now, if people want to be housed in a transgender housing unit or they need protective custody, it should be based on a case-by-case basis and based on their gender identity, or the lack thereof, because we do have the gender nonconformist movement. But this jail is not conforming to the PREA standards. They deprived me of my HIV meds for 5 days, and I told them from the time that I was arrested that I was positive, that I was undetectable, and that I needed my HIV medication. And there's proof, because when I entered the jail at Rose M. Singer, they tested me for HIV through the rapid test. It was negative. When they drew my blood 5 days later without my HIV meds, my viral load had risen to 141. So I was then now HIV positive again. And the risk associated with that type of medical negligence is great, because when you don't take your medications, you can form a mutation, you can form a resistance. This put me at a great risk. Not only that, they did not give me the medications that were prescribed by my doctors for my gender identity and the hormones and stuff like that. It's a bit difficult for me to talk about these things because I don't really like to think about it, because I really do identify as a female. And so, you know, these are things that I just do in my daily routine that I don't like to talk about because it's a bit hard. But, you know, like this, they separate you from the moment that you come in the door. You're not kept with other female inmates. And one of the first days I can remember the girls, the cis women in the cell, I don't even like that separation. We're women. The other women in the cells that were held together would say, why do you guys have her by herself? They're like, hey, are you okay? And I'm like, I don't know. And they're like, oh, it must be a tranny. And it's like, you know, these people are subjecting us to such violence and such ridicule and such sexual harassment because it's not what they're supposed to be doing. What is the point of even putting us at a female facility to then be housed by ourselves? So you're telling me if there's only 2 people or 1 person that are identifying as trans in the facility that you're gonna be housed in an entire unit by yourself? That's solitary confinement. You're still in solitary confinement. It's no way around it. Like, integration is the only option. We have to stop policing people and their gender and their sexual identity or sexual orientation. And can I make a point of it to say that gender identity and sexual orientation are different? You have transgender women or people who identify as female or male who don't like sex at all. You have people who identify as female who are pansexual, which means they're open to whatever. You have people who identify as heterosexual, bisexual. We have to stop policing sex in jails as well. Because at the end of the day, I feel like the policies and the procedures that are being developed are solely based around them trying to prevent sex happening in a jail, which we all know you can't stop people from doing things together. At the end of the day, like, you know, they'll find a way around it. We're policing the wrong issues. At the end of the day, I think what's most important is preserving people's integrity. Because for someone like me who went through this experience going, I have no clue why I'm in here for this. I had nothing to do with this because I was the victim of a police department who had, you know, I was guilty by way of being transgender. They just assumed that I was guilty because I was there. And thank God that I was able to make it out of this situation, to speak for my community. And I just cannot say enough how, yes, they are making progress. There is progress. We are making progress. We are making steps in the right direction, but it's not integration. And I think that anyone who turns the other way or anyone who doesn't make a change immediately is complicit.
So I would, if you agree, if you can give your name to our staff, because I think, as I said earlier, anytime we can use an upfront and close case, something recent, where we could look at, okay, here's the policy that you said you have. Here's somebody who was just released 3 weeks ago, and this is what they went through. And so we could test the reality of their policies and to make changes. And, you know, we can talk, but when you have someone's real life experience about what it was like to go through there and
They
how
told me I
you
looked like a
experienced
science
it.
project.
So if you don't mind, I think this is a great opportunity to be able to talk to DOC about that. And I just want to thank the Sylvia Project for, you always are bringing examples of real life experiences of people who are impacted by the policy. So thank you.
I cannot stop thinking about this. I don't think that I will ever be the same after this experience, because the reality is that these people are saying one thing and doing another, and it's really, really disturbing because these people are thrown away already by society, a lot of them by their families, a lot of them by, you know, they're vulnerable, they're weak, they're not heard, and they're just being thrown away, and they feel like no one cares.
Well,
How
you're
long
gonna
were you
be-
at Rikers? I'm sorry.
17 days.
Yeah. Well, you're going to be part of the solution. So thank you. Thank you all. We have 2 speakers left. Three speakers. Alice, Savannah, and Kelly Grace. Is Alice here? Okay. Savannah?
She just spoke.
Oh, she just spoke. Okay, perfect. Kelly, you're up.
Hi. I'm just going to make a few. I'm Kelly Grace Price from Close Rosies. And I'm sorry, but he's a service dog, so he's not supposed to do that. I apologize. He's only 9.5 months, and this hearing is testing his patience. So I want to start off by letting you know that I produced my own PREA audit report for the board, and I'll turn it in this afternoon. I really want to ask the board to focus on producing a comprehensive PREA audit report. I know you guys are trying, and I know that you had really great staffers working on it. I thought Cassandra was really great. I thought that the information that she supplied in her October reporting audit was fantastic. I heard from people in the DOC that she had amazing rapport with them and that they loved working with her, and she was fair and they got things done, which by itself is sort of the job qualification, right, for the BOC PREA auditor to be able to get along with the DOC. I have real serious misgivings about why she was let go by the board. I don't want to hound on this too much, but I just want to start off by saying there should have been redundancy in her position. We should have a comprehensive document in front of all of us right now for this hearing, produced by the board, that's just a compendium, an aggregate of all the information about compliance, evidence of non-compliance, comments, suggestions like Marlon's for rule change proposals, all this stuff. I mean, we're so far along. I'm thinking of the first time that I appeared in front of the BOC back in December of 2014. And so much in my life, you've seen that I've changed and I've gotten better, but this issue just is persistently not getting better. So instead of going through the PREA audit report, I'll send it to you and hopefully we can have a conversation about this, and hopefully this document can be a starting place. I do want to thank the board for the information that you guys provided this morning. I was so grateful to finally see a data chart on page 4 that began to chart the history of complaints, what's been closed, what hasn't been closed. You know, there are a lot of problems with trying to understand as an advocate, as an outsider, exactly where our closing rates are, where our substantiation rates are. I'm having an extreme amount of trouble still trying to understand why complaints are being disappeared. For instance, in the report that you provided yesterday, you took pains to break out PREA versus non-PREA complaints, but I felt like you were kind of doing the department's work for them. I'll skip over that, but there's a lot more to be said. That particular PREA, non-PREA bucket, there's so much work to unpack.
what's going on there. I know you guys know this. Some quick observations. You know, the population of the island has dropped dramatically. The population of Rosies is down to 60% in the last 5 years, but the complaints aren't. You know, these are huge problems. I have some suggestions, and I want to focus in on just a few of the PREA standards where I feel like, you know, there's some really easy remedies for trying to rip back the veil of opacity on this information. For instance, a lot of people talk today about video surveillance. It's board standard 504G on buses. The report that the department provided earlier this year, analyzing their two choices, the body-worn cameras or the Genetec cameras, that everyone knows this. You're providing two false choices. Neither choice is good. There's more than just those two choices. Why do we keep accepting that there are only these two choices? The expensive Genetec solution that's cost prohibitive, what is it, $150,000 per bus or something, might be more than that, Dory, Kayla. Anyway, or the stupid body-worn cameras that are not efficacious and they can be switched up. There has to be some other choice here. Why are we going to let them get away with just presenting these two choices? It's ridiculous. Someone needs to be holding their feet to the fire. You know, regarding prevention, let's just talk about the staffing plans. They keep saying, oh, we provided the staffing plans, but there's so much detail level that's missing from all those, and it's just not one staffing plan. There's 2 or 3 different staffing plans that we still need a lot of detail level about. You know, the PREA coordinators in the facility. Why are we, in September, Ms. Townsend said, oh, we had 5, we just hired 2 more, we're gonna have 7. And they keep saying, oh, back in 2017, the department was only budgeted for 8. Well, what about 2018, what about the subsequent years? Is the department repeating the same mistake, only budgeting for 8? You know, why aren't they changing? Why are we accepting the same status quo excuses for lack of implementation at hearing after hearing after hearing? We heard Cassandra say in October that we were back down to 5 compliance managers for the individual jails because of attrition. We'd lost 2. So why isn't someone insisting that the DOC staffing plan includes redundancy in these positions? They're integral. We have to have redundancy. We heard the Westchester guys say that their manager in every facility is the point person. Well, what a great idea. So maybe a little encouragement for staffing, because again, I know a number of people that have applied for these jobs. Barbara McLean is a SART expert who's testified in front of the board back in June 2016, July 2016, and November 2016. She's applied several times for a number of different open DOC positions, never even been given an interview. So I'm trying to figure, oh, is this the timer right here?
Derek has the time.
Yeah, you have, let me just, you're over your 6 minutes.
Okay, so then I will send in my report and my dashboard today, and I'd like to continue this conversation. But let's just talk about my own anecdotal experience of nearly being raped on Rikers. You know my story. Dr. Hansey, who's going to trial finally in June, tried his little role of conscription by overprescribing medications to me. But who is, to Ms. Herzog's and Sarah, to their points, who is really doing the training and seeing if the training is efficacious on little things like warning signs? When I was overprescribed those prescriptions by Dr. Hansey, there should have been a report that I showed up at my housing unit with 300 individually wrapped Tylenol pills. Somebody should have been asking questions. Why does Ms. Price have a whole tube of bacitracin and 30 guaifenesin tablets? That's a warning sign. That doctor was trying. So, and this is in my report, a question that needs to be asked the DOC. Have they ever documented any report from any staff or consultant of a warning sign? Has that ever come across? Because that's proof of efficacy of the training, right? If these things are being documented. But we've never heard of anything like this. And the same goes for, we heard CHS and DOC say that they do screenings for staff and consultants when they hire them. But we haven't heard exactly how many people have had dispositive results from those screenings. So again, thank you for having this hearing. I'm exhausted, Frank's exhausted. I've done my best to document all these things, and I really hope to work with the board to improve these conditions, but we can't do anything if we keep having this staffing problem. It comes down to the number one thing I think the board should be doing right now is interviewing for not one, not two, but 3 PREA compliance managers, because you really need those people. I'm not going to be putting in my application, but as always, I would love to work with them. Thank you so much.
Yep, thanks very much. Is that everybody said? That's it. Well, I think we've heard from everyone from the public who wants to testify, so I think now the meeting's adjourned. Thanks very much, everyone.
Yes. And I would recommend one change when we have a special hearing like this. I think the stories of people telling their experiences when they were in, or they are delivering messages from their clients, having that at the beginning of the hearing when everyone is here. Not the whole public comment, but those stories are really important for DOC to hear. We don't have to do the whole public comment, but the stories are really powerful and they need to hear them because it gives them an opportunity. It's not a right or wrong thing, but it does give them an opportunity to look into their process and see where they could have improvements so we can get better over time. Thank you.
Quite a day.